Okay, good morning. Welcome to the September 16th, 2013 meeting of the Tennessee Real Estate Appraiser Commission. First item of business is the call to order and roll call. So beginning at my left, please state your name and where you're from.
Eric Collinsworth, Arrington, Tennessee.
Nancy Point, Rogersville, Tennessee.
Gary Standifer, Franklin.
Michael Green, Johnson City.
Norman Hall, Brentwood.
Rosie Johnson, Paris.
Ed Barilla, Johnson City.
Thank you, Dr. Barilla. Next item is to adopt the agenda. You have before you the proposed agenda. Do I hear a motion to accept this?
So moved.
Second.
I have a move from Commissioner Hall and a second from Dr. Barilla. Any discussion? All those in favor say aye.
Aye.
Any opposed? Hearing none, motion passes. We have our agenda. It's important for everyone to note that this regularly scheduled commission meeting is taking place in the first floor conference room of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. Notice of this commission meeting was posted on the TREAC website, TREAC website, on August 28, 2013. Next item is to review the July commission minutes. Has everyone had a chance to look at those? Do I hear a motion?
I so move that we accept.
Second.
Motion to accept from Commissioner Point and a second from Commissioner Hall. Any discussion? Hearing none, all those in favor?
Aye.
Any opposed? None opposed, motion passes. The minutes are approved. Next item on the agenda is the 2014 calendar. And this is proposed by Ms. Avers. Ms. Avers, would you like to present and comment?
Yes, if you turn on your iPads to page 16 on the iPads, if you tap the screen, it'll give you page numbers, and then it'll turn to page 16 on the iPads. The dates are signified in red. The proposed dates are January 13th, February 10th, March 10th, April 7th, May 12th. No meeting in June because of continued conflicts with the CMA Music Festival in Bonnaroo. It just seems like the hotel rooms are impossible to get in June. So I just didn't book one at all in June for 2014. July 14th, August 11th, September 15th, October 13th, November 10th, and December 15th. Very important as we head into 2015 that the dates all the way through the end of the year is going to be very busy with trainees applying in those last 3 months.
Of 2014.
Right.
Okay. All right. Have you accounted for the fact that the Titans may be in the playoffs?
Really hadn't factored that in. I'm sorry.
I just thought I might ask and see if that, okay.
Guess we could always revise as needed.
Okay, excellent.
When the Titans play the Redskins, then I think we should have a holiday, don't you?
Yeah, or a day of mourning, perhaps.
Somebody will have to notify me. I'm not familiar with the Titans schedule.
Okay. Yeah, and there's that in and of itself, I think, is suggestive. Sorry, we'll move along here. Any other comments, Ms. Avers? No. Does commission members have any comments? Do you see any conflicts or any things we need to note? Okay. All right. Well, hearing none, do I have a motion to accept the 2014 calendar?
So moved.
Second.
So a motion by Dr. Barilla and a second by Commissioner Hall. Any other discussion? Hearing none, all those in favor?
Aye.
Aye.
Any opposed? None opposed. The 2014 calendar is approved. Moving along to the education report, Dr. Barilla.
Thank you, Mr. Chairman. First items to go over are 3 courses from the ASFMRA, 16, 77, 78, and 79 regarding their conference. 6 hours, 3 hours, and 6 hours continuing education. I would recommend 4. The Appraisal Institute has 2 courses, their Atlanta office, 1680 and 81, 14 hours continuing education and 7, and I would move for approval of those. Northern Michigan University has 3 courses, 1682, 83, and 84, 2 hours, 2 hours, and 3 hours for continuing education. I'd recommend 4. The Appraisal Institute has 4 courses, 16, 85, 86, 87, and 88, with 4 hours, then varying times whether or not there is an exam administered. For continuing education, I'd recommend 4. The NAIFA has 2 courses, 1690 and 1691. For their conference, 7 hours each, I would recommend 4. Now, Virginia Commonwealth University, if you flip your iPad to the 2 pages afterwards, you'll see a letter from VCU addressed to Nicole Avers, dated July 16, 2013. Their BS program in real estate, the Bachelor's of Science, and their Master's of Science programs in real estate were approved and accepted by the Appraisal Foundation, and they've asked us to accept that recommendation by the Appraisal Foundation to request the Tennessee Appraisal Board recognize the approvals by the Appraisal Foundation and also award credit for VCU's real estate curriculum to VCU graduates seeking an appraiser's license in Tennessee. And I would recommend, for both of those. And if you flip your iPad again to the next page, the Appraisal Foundation recognizes some deficiencies in the program, and I wanted to read the deficiencies into the record so that we're all on board with that. In each instance, the program for the BA in real estate does not include, or the BS in real estate does not include the USPAP, so that would be a deficiency even with credit for a trainee, licensed residential, certified residential, or certified general. Students would still have to complete the 15-hour USPAP course. In addition, in the certified residential, they would have to complete a 15 hours of advanced residential applications and case studies. And then for the certified general, they would also have to complete coursework in general appraiser sales comparison and appraiser site valuation and cost approach. Now, for those students who complete the master's degree, they would have deficiencies in the USPAP courses, and then again the 15-hour advanced residential application. But instead of, let me see. Instead of 15 hours of the site valuation, as in the BS, they would need 10 hours is the difference there. So I would recommend approval of those with those stipulations that there are deficiencies that the AQB recognized and that we recognize those as well. Insofar as individual course approvals, we had one from Nancy Point, 7-hour USPAP update. I would recommend 4. Doyle Monday, 13 hours. I would recommend 4. Property tax seminar. And Michael Orman, an investigator training course, 17 hours. I would recommend 4. And that would complete the education report. And I'd like to express my appreciation to our director and Dennis for the work that they've done. You see the final report here, but we go through a lot of back and forth in getting information put together and deficiencies and everything else. I'd just like to express my appreciation for the work that they do besides the scene on our behalf. That would be it, Mr. Chairman.
Thank you, Doctor. So just to clarify, so the VCU programs, you recommend that we accept them for qualifying education, how do the deficiencies, how do we end up handling the deficiencies? Do they, basically with the degree, they qualify for the QE, Ms. Avers? I'm not sure I understand, practically speaking, how this will be implemented.
If they submit the degree, they would have to submit the degree, and then they would have to submit also, depending on which credential they were applying for, the remaining continuing or qualifying education hours. So they would, if they were applying for first trainee, they'd have to submit the degree and 15 hours of USPAP. And then later, if they were applying to upgrade to certified general, they'd have to submit the degree, the USPAP that they've already taken, and the two other courses, general appraiser sales comparison approach, and general appraiser site valuation and cost approach. It says 15 hours on each, but there is actually no such thing as a 15-hour sales comparison.
We're not, so
It would actually be a 30-hour course for each of those.
by approving these for QE, it's really an approval for QE subject to some additional,
Qualifying education.
and that's stated clear enough for it to be on the record and official?
Right.
Okay.
We will have to post it to the website in a creative way, but
So sort of an asterisk, see below kind of thing? I got you.
I will have to think outside the box, but yes. If nothing else, it'll be for sure in the website, in the minutes, but I will have to think of another way to post it for qualifying education. For purposes of discussion, I would recommend that it be only during the approval period of May 2nd, 2013 through May 2nd, 2016, because that's how long the AQB approved it for.
And is that typical? Is there a sunset on a lot of this stuff?
They've approved other degree programs. There's one in Texas. I can't think of it right this morning. I'm rolling on other things in my head right now, but there's a degree program in Texas that the AQB approved for qualifying education. Just can't think of the name of the college right this moment. They haven't applied to Tennessee for credit, but if they did, I think it would be very reasonable to extend a similar
University
credit.
of Georgia, Nicole, does the University of Georgia have this same program?
I really don't know.
Asked that question is I remember several years ago, the Appraisal Institute worked with the various colleges about approving curriculum that they could present and satisfy the requirements. Of course, this was before USPAP. And I remember at that point in time, I did the review for Virginia Commonwealth University program, which we approved back then. And so it sounds like to me that this program kind of complies, except for, like Dr. Barella has adequately pointed out, that does not meet the USPAP portion of it. And
There's a few of them. I just
So-
can't call them off the top of my head right now. I think Colorado has one also. I just can't think of them right now. And
I
as
just
they
wonder
apply
how
to
we-
Tennessee, I think that we'll see this more and more where there's real estate programs that may have some level of credit.
I would suspect that no one's going to have USPAP.
No problem, no problem. I hope everything's all right. Okay, all right. Let's see. Well, our thoughts and prayers are with Commissioner Hall. Do we still meet the criteria for our meeting? Still good, okay, all right. All right, so we've had the education report presented and recommended for approval. Do I hear a motion in this regard?
I so move.
Second.
So we We have a motion to approve by Commissioner Point and a second by Commissioner Johnson. Any other discussion? Hearing none, all those in favor, say aye.
Aye.
Any opposed? Hearing none, motion passes. Education reports approved. Before we move on to the next item, which is the formal hearing, I didn't see it on the agenda, but we do have one brand spanking new commissioner, and we have one almost new commissioner. So beginning with Eric Collinsworth, we want to welcome you.
Thank you, sir.
Appreciate you coming. You're
Glad to
from
be.
Nashville?
Arrington, yes, very close to Nashville.
Arrington, okay. And then Mr. Gary Standifer is brand new to us, and you are from Nashville. Correct.
I'm from Franklin. My
Franklin.
office is in Brentwood, and all my clients are in Nashville.
Is no one from Nashville? Well, we welcome you. We appreciate your service.
Thank you.
Sure. The commission will take a 5-minute recess before the next item on the agenda, which is the formal hearing.
So I don't know.
All right, the Real Estate Appraiser Commission is back in session. This is the September 16th meeting, and we are down to the point in the agenda where we'll have our formal hearing. Turn the meeting over to Mr. Joseph, please.
Thank you very much, Mr. Chairman. Mr. Chairman, first, as a matter of personal privilege, let me take this opportunity to introduce to the entirety of the commission our new Deputy General Counsel for Regulatory Boards, Mr. Samuel Payne, who is sitting to my left. Mr. Payne comes to us from the Attorney General's office, where he was in the tax division that handles many of our appeals. Mr. Payne also private practice, working with the firm of Evans, Jones, and Reynolds and several other firms for the past 15 to very happy to have him, and he's going to sit in today with me as co-counsel, and you with what all of our 22 to 25 regulatory boards do, and we're happy to have.
You start speaking in tongues and we'll.
Honorable Judge Williams.
Thank you. Today is Monday, September 16th, the year 2013. This is a hearing conducted by the Tennessee Real Estate Appraiser Commission. The commission is chaired by Commissioner Michael Green, and the commission will be considering today the case of Appraisal Valuation Services, docket number 12.36-121803A. Appraisal Valuation Services is unregistered as a Tennessee appraisal management company. My name is Madeline Williams, and I've been assigned by the Secretary of State to serve as administrative judge. Assistant General Counsel Jesse D. Joseph represents the state in this matter, along with Deputy General Counsel Samuel Payne. It appears that Appraisal Valuation Services is not present today. What evidence, Mr. Joseph, do we have that Appraisal Valuation Services was notified of today's hearing?
Well, Your Honor, we filed, as Your Honor is aware, for the record, on September 5th of this year, a motion to deem service of notice sufficient. And within that motion, we set forth that we have sent 2 certified mail copies of the notice of hearing and charges to the 2 last known addresses of this respondent in both Indianapolis, Indiana, as well as in Westfield, Indiana. Both of those attempts came back unclaimed. We have also submitted for the court as an attachment to our motion the affidavit of our Executive Director, Nicole Avers, which sets forth that Mrs. Avers attempted to contact the respondent via telephone. We don't have a mailing address, a firm mailing address for the respondent. Mrs. Avers attempted to find additional information via the respondent's website, and all indications given to Mrs. Avers and her staff was that the respondent claimed that we had the wrong business. They would not provide us with a mailing address, and we simply cannot get them served with certified mail. As a matter of fact, Mrs. Avers' affidavit sets forth that one of the respondent's representatives by the name of Kim Coleman indicated that they had sent mail back to us. So we were of the opinion that either the respondent does not want to be found or that the respondent has evaded service of process. And given the fact that the respondent has no registration as a AMC, we have no formal address for the respondent or listed address, and submitted that that was all we could reasonably do. And Your Honor, if I'm not mistaken, entered an order on September 9th granting that motion. But in addition to that, we do have, of course, as Exhibits 1, 2, and 3, copies of our certified mail notices to the respondent that were returned unclaimed, as well as a copy of a Google printout from the Office of Legal Counsel setting forth a 4222 Broadway Street address in Indianapolis, Indiana. And based upon the respondent's failure to be served, failure to be here, failure to cooperate, we would ask that the respondent be declared in default.
I find the evidence of attempted service to be sufficient to hold the respondent in default. It's up to the commission members whether or not to hold them in default, and also to approve going forward in their absence. I would turn that over to the commission.
Thank you, Your Honor. Well, it would seem that there was no representative here. It would seem that they've been given ample notice. Do I hear a motion to declare them in default?
Second.
Okay. I have a motion from Dr. Barilla and a second from Commissioner Johnson. Is there any other discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? Motion to declare the defendant in default is approved.
Also, a motion to proceed in their absence.
Do I hear a motion to proceed in the absence? Second, anyone? Second. Any discussion? All those in favor say aye.
Aye.
Any opposed? None opposed, so we move forward, Your Honor.
All right, thank you. I will make rulings regarding the order of proceedings, admissibility of evidence, and questions of law under the authority granted me by the Tennessee Administrative Procedures Act, but I will not participate in the findings of fact or the ultimate decision of this commission. Those decisions will be made by the commission members. At this time, I would ask the commission members to introduce themselves for the record, starting with the gentleman to my immediate right.
Eric Collinsworth.
Nancy.
Gary Standifer.
Michael Green.
Rosie Johnson.
Edward Barilla.
Thank you. And a quorum exists. Members of the commission are reminded that during the time this hearing is being conducted, no discussion of this case should take place between commission members, witnesses, attorneys, or other persons unless all parties are present. This commission sits as a jury and must only consider evidence introduced at the hearing in reaching its decision. The Sunshine Law requires all commission discussions and deliberations to be in public before all parties. Failure to observe the Sunshine Law may result in the commission's action being reversed or remanded if appealed. Commission members, you should not draw any conclusions until all of the proof has been heard. Please listen to all of the proof with an open mind. Before going further, I would remind the members of the commission that the law requires you to disclose on the record any outside knowledge of this case or any communications you've received, written, verbal, or otherwise, from any parties concerning this case. At this time, I would ask the state to distribute the notice of hearing and copies of law and applicable rules. We will take some time for the commission members to read the notice of hearing so that you can determine whether or not you have a conflict of interest or have received outside information with regard to this matter. Looks like the commission members have had a chance to review the notice. have anything to disclose? Any conflicts, any outside information? During the course of this hearing, there will be opportunity for each of you to question each witness that testifies under oath. Please use your questions as opportunities to gain any clarifications of the facts that you feel would assist you in reaching a decision in this case. However, you must reserve any expression of opinion you may have to that portion of the hearing that is set aside for the Commission's deliberations after all of the proof in this matter has been heard. The pre-hearing technical record in the appraisal valuation services matter includes the following: June 28th, 2013, notice of hearing and charges. July 2nd, 2013, an opening letter from Judge Williams. September 4th, 2013, notice of intent to introduce affidavit of Eric T. Sargent. September 5th, 2013, state's witness and exhibit lists. September 5th, 2013, state's motion to deem service of notice complete and sufficient. September 6th, 2013, service of notice deemed complete and sufficient. Mr. Joseph, are you aware of any additional documents that should be a part of the pre-hearing technical record? All right, then. I will enter those documents as a technical record to date. At this time, I'd like to swear in the witnesses who are going to testify. Understand there's one live witness, is that correct? And that's going to be Ms. Avers. Do you, yeah, right, yeah, correct, right hand, please.
Sorry.
Do you swear or affirm that the testimony you're going to give during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. The witness is now sworn. Are there any preliminary motions or stipulations, Mr. Joseph?
No, Your Honor.
Opportunity for opening statement.
Thank you. That appraisal valuation services is an entity operating the state's proof will show that Eric Sargent, a certified residential appraiser in Tennessee, some point in the spring of 2012, Southwest Funding directed him to receive his appraisal order Sargent performed 7 appraisals for this client through appraisal valuation services between April and June. Sargent was never given a specific mailing address for the Sargent was told, and the state's proof will show, by the respondent's representatives that they had an application also showed that by the late summer of 2012, going into the fall, that Mr. Sargent did not get paid through www.ebill Pay Us. Not getting any answers from the respondent's representatives as to why he was not receiving. All of 2012, the respondent removed Mr. Sargent providing him any written notification of the reasons for his removal. November of 2012, when Mr. Sargent filed his complaint with the staff of this commission, all of his invoices were more than 60 days past due, and not been paid through the present. Proof will also show that the only information which Mr. Sargent could obtain from the respondent's website, which was www.appraisaltogo.com, were 2 phone numbers, which were the same phone numbers to go.com. Based on all of the proof which the Commission will hear in this matter, the state will contend that the of Tennessee Code annotated 6239-403 an appraisal management company from engaging in unlicensed. Also, the respondent's conduct is in violation of Tennessee Code is further in violation of Tennessee Code annotated 6239-421, which states that a respondent must pay appraisers within days unless there is some specific notice given to appraiser. Finally, the respondent's conduct is in violation of Tennessee Code annotated 39-424A1, which states that it is a violation for an appraisal management company to remove an appraiser all the proof. The state would ask the Commission for the following. Given the fact that the respondent has no appraisal management company license, the state would ask the Commission to enter a civil penalty at least in the amount of $28,000, calculated as follows. Based upon 3 major violations. First of all, $15,000 for performing services as an appraisal management company without being registered at the rate of $5,000 per month for a minimum of 3 months between April and second major category would be $12,000 for failure to pay Mr. Sargent the amount of these past due invoices at the rate of $1,000 12-month period from June 2012 through June 2013, which was the date in which the state filed this notice. Finally, $1,000 for improperly removing Mr. Sargent from its approved appraisal panel without notice, all pursuant to Tennessee Code annotated section 561308. At the conclusion of all the
Thank you for your opening statement. Your first witness, please.
Thank you, Your Honor. Your Honor, before we ask any questions of Mrs. Avers, for the record and pursuant to the state's list of witnesses and exhibits, we'd like the record to be complete as to the state's efforts to locate the respondent and to serve the respondent with the notice of have provided as proposed exhibits number 1, a copy of the certified mail notice that went to the Westfield, Indiana address that was returned unclaimed.
All right, those documents are entered as exhibits 1, 2, and 3. may distribute copies to the commission members.
Thank you. Thank you. Your Honor, in order to continue our enumeration for our pre-marked exhibits as set forth on our state's list of witnesses and exhibits, as the court notes from the technical record, we have served the respondent with the affidavit of Eric Sargent. That there was no request to cross-examine Mr. Sargent. Mr. Sargent also certified within his affidavit 2 sets of business records from his office, those being his invoices, as well as his complaint that he submitted to this board. As a consequence, the state would request the ability to enter into evidence as exhibits 5, 6, and 7. 5 being Mr. Sargent's, 4, 5, and 6, pardon me. 4 would be the September 3rd, 2013 affidavit of Mr. Sargent. 5 being Mr. Sargent's accounts receivable, which lists his 7 past due invoices. 6 being the complaint that Mr. Sargent signed and submitted to the board's administrative staff.
All 3 of those exhibits are admitted at this time, and copies may be distributed to the commission members.
Thank you.
Nicole Marie Avers,
And what is your business address, ma'am?
500 James Robertson Parkway, Nashville, Tennessee. Yes.
And how long have you been an employee of this department, ma'am?
7 years.
And what is your title?
Executive Director.
And how long have you acted as a director for the Department of Commerce?
7 years.
And what are your general duties, Mrs. Avers, as Executive Director for the Tennessee Real Estate Appraiser Commission?
My job duties involve oversight of all administrative responsibilities of the commission, including processing of registration, applications, license applications, certification, approval and requests for continuing education and certification, or continuing and qualifying education, processing complaints, and all other administrative responsibilities.
Are you the official custodian of the board?
Yes, I am.
Are you familiar with an entity by the name of Appraisal Valuation Services?
Yes, I am.
And how are you familiar with that entity, ma'am?
They're a respondent in this complaint matter.
What was the nature of the allegations of this complaint?
The complaint filed by Eric Sargent was for unpaid invoices.
Have you prepared an affidavit in this matter, Mrs. Avers, setting forth your efforts to locate this respondent, to serve it with the notice of complaint, and to assist my office in attempting to...
Yes, I did.
Document which I'm showing you right now, a copy of that affidavit which you executed for my office.
Yes, it is.
Did you sign that document on September the 4th, 2013?
Yes.
Is it true and correct to the best of your knowledge, information, and belief?
Yes.
Do you maintain a true and correct copy of it within the official record?
Yes.
And do you have a business duty to do so?
Yes.
Your Honor, we ask that the September 4th, 2013
The affidavit is entered into evidence as Exhibit Number 7 at this time, and you may distribute copies to the board, to the commission members.
office, Mrs. Avers, received the complaint in this matter against the respondent?
Middle of November 2012.
Does the respondent, Appraisal Valuation Services, have an appraisal management company registration in the state of Tennessee?
No.
Has the respondent, Appraisal Valuation Services, ever applied for an appraisal management company license in the state of Tennessee?
No.
Given any mailing address for the respondent on the complaint?
No.
Looking at page 2 of your affidavit, which is Exhibit Number 7, explain to the commission and to the court what you and your office did.
In November, November 19th, my administrative assistant, Iman Youssef, researched the internet attempting to locate the respondent and initially came up with Appraisal Valuation LLC located in Oregon. An email inquiry was sent to this respondent and then sent them a letter to the address also. The respondent in Veneta, Oregon, and she CC'd Southwest Funding LP in Dallas, Texas. On November 20th, it was found that that was not the correct company, and we researched the internet again. Google search revealed a name of Terry Smith as a contact person, and address possible of P.O. Box 598 Westfield, Indiana 46074. And we sent a second notice of complaint letter, enclosed a copy of the complaint to the respondent with attention Terry Smith.
All right. You indicated, did you not, that you sent an initial notice of complaint to an by the name of Appraisal Valuation Services LLC in Veneta, Oregon?
Yes.
Is this a copy of that letter that you just testified to that your office sent to that wrong respondent in Veneta, Oregon?
Yes.
Do you maintain a true and correct copy of this November?
Yes.
And do you have a business duty to do so, ma'am?
Yes.
Your Honor, we ask that the November 19th, 2012
Documents entered as exhibit number 8 at this time, and you may distribute it to the commission members.
just testify on direct examination that your office sent a second notice of complaint letter to this respondent after doing additional internet?
Yes,
November the 20th?
yes, we sent out a second letter to Appraisal Valuation Services to a modified address, this time to Westfield, Indiana.
And what happened on that November 20th, 2012 notice of complaint letter that your office sent?
It was returned to us. It was returned to sender.
Is a copy of the document which I'm showing you now as the next proposed collective exhibit
Yes.
do you maintain copies of these documents within the official books and records of the?
Yes.
And do you have a business duty to do so?
Yes.
Your Honor, we ask that the November 20th notice of complaint letter that was sent to the respondent after
The collective exhibit 9 is introduced and admitted into evidence at this time. And you may distribute it to the commission members.
Mrs. Avers, based on your research in this matter, were you able to determine what the respondent's website address was?
Yes, I believe so.
And what is that website?
It's www.appraisal appraisaltogo.com.
And where did you get that information from, ma'am?
Well, it was pretty clear from their email address. The complaint included request@appraisaltogo.com, and that email address is on their website. So is their phone number. And so I researched the internet, searching by their email address and searching by their phone number, and the website came up.
All right. And what did you find based on your email, based upon your research, ma'am, on that website?
The phone numbers were 317-844-7-AVS, which is 7287, and 800-993-6207. The email address, request@appraisaltogo.com. That's the email address what was on the complaint.
Were those the same phone numbers and email addresses as were contained on the complaint that was submitted?
Yes, if you look on the first page of the complaint,
That is Exhibit 6.
Exhibit 6, his complaint includes a phone number on the telephone line of 800-993-6207, and the line below it, the email address, request@appraisaltogo.com.
Did your office print out any copies of pages from the respondent's publicly available web?
Yes.
Copies of the documents which I'm showing you now as the next proposed exhibit, copies of pages from the respondent's.
Yes, they are.
And you maintain true and correct copies of these documents?
Yes, I do.
And do you have a business duty to do so, ma'am?
Yes.
Your Honor, we ask that the publicly available
Pages are admitted into evidence as exhibit number 10, and you may distribute copies to the commission members.
Thank you. Find the website of the respondent still functioning as of early.
Yes, they were functioning as of August 30th, which is the last time I searched the website for them.
Did your office perform any other internet research to locate a good mailing address for this respondent?
I've searched the internet multiple times trying to find a good mailing address for them, and I've even called them.
Respondent in this matter.
I phoned them on August 30th.
And what did you find out?
I called them on the morning of August 30th, and it picks up by an automated service that says, "Appraisal Process Center, please hold while I connect you." And a Mr. Dominique Fields answered, and I told him why I was calling, and he...
For the record, excuse me, you're reading from your affidavit.
Yes, I am.
All right, thank you, ma'am.
I told him, you know, I was calling about unlicensed conduct as an appraisal management company, and he did not dispute being an appraisal management company. I informed him that I'd made multiple attempts to reach that company, and I wanted to get an address. I requested the address and name of a person to serve the notice of hearing and charges with, because we'd been trying to serve them the notice of hearing and charges for several months. He wouldn't give me an address or a name other than his. He said he'd have someone call me right back. I was hesitant to get off the phone because I said I'd been trying for a really long time to get a hold of someone. And he said he'd have somebody call me right back. And he wouldn't give me the name of who was going to call me right back. And, but the website and phone number was still working as of that date. A few minutes later, a lady named Kim Coleman called me back on a restricted phone line. She said she had received some of our mail and sent it back to us. But she said we had the wrong business and said that she didn't do business in Tennessee. I said that I asked her if their company was an appraisal management company. She said no. And I said, well, I'm on the website and it kind of says that you are. And she got really hostile on the phone. And she said, we don't do business in Tennessee, though. And I said, well, I have documents that say you do. And she said, well, we don't do business in Tennessee. And I said, well, how do you know if you haven't looked at the documents? And I said, well, can I fax them to you or email them to you? And she said, we don't do business in Tennessee. And I said, can I just get an email address or a fax number for you? And she said no. And I said, do you work with Southwest Funding? And she hung up on me.
During all that discussion, did you ever obtain, or were you successful in obtaining a good mailing address for the respondent in this matter?
No.
What is it about the respondent's website, which has already been entered into evidence as exhibit number 10?
Well, it seems to offer services for appraisers, loan officers, brokers. It seems like a mediation service between all of those. The name of the company and the login. I couldn't get past it without a user login name. All of those links require you to log in. So all you can get is email address or phone number and then the login prompt. There isn't too much information you can get beyond that. It seems like an appraisal management company, but it also seems kind of evasive at the same time, like you can't get past this prompt. There's no address on any of those links at the top.
Was there also a link on the website for brokers?
Yes.
And was there a link for loan officers?
Yes.
Have you been able to obtain any other information about this company?
There was on the internet there was an appraiser had posted a order from Southwest that had appraisal valuation on their order. I don't know why they posted it. It must have been an error, but it didn't have an address on it, so I didn't include it in the documents.
Were you able to determine what area code or what city area code 317 on a phone number would be?
It was in Indiana, in Indianapolis, Indiana.
Did you contact any representatives of the state of Indiana real estate appraisal?
Yes, I did.
And what did you find out?
They're not registered in Indiana as an appraisal management company, and I did an independent search of their website just to verify they have their AMCs listed on their website alphabetically, and they're not listed there either.
Did you do any research on a national registry to determine if they were registered?
No, I did not search a national registry for appraisal management companies.
Thank you very much.
Commission members, this is your opportunity to question the witness.
Open the floor for the commission members to ask questions. Mr. Collinsworth, would you like to start? Do you have any questions for the witness?
I do not have any questions for the witness.
Commissioner Hall? Wait.
No questions.
Okay.
This is the only conduct I'm aware of. There wasn't a large internet footprint available for them. Just this website, and then someone had posted one of their orders to the website, which sometimes happens. It was a service order that listed the client's name, and they had posted their appraisal to the website. But there wasn't a good address on the actual AMC on that. So I couldn't that as additional documentation. All I had is the name of the company again.
First time that the appraiser involved had ever dealt with this company?
I don't know.
Commissioner Johnson? Dr. Barillo?
I have no questions. Thank you.
I have a few. On Exhibit 10, I note that we have two big black spaces.
Color, but yeah.
So that, just for clarification, that exhibit, that's the way the website appears. There's nothing in this dark space.
It's blue, but yeah.
That's not a printing problem. That's a true representation of what the screen looks like.
Yes.
Okay.
Other than the fact that the black would be blue, yes.
Okay, thank you. I just, sometimes when you make copies, there's things there, but it doesn't discern, so I
No.
wanted to clarify that. I need to understand, well, does the state of Tennessee have a formal definition of what an AMC is?
Yes.
Can
And
you
if
read
you
that
turn on
to
your
us?
iPads, it is posted in your iPads, the laws and rules for the Appraiser Commission. Tap your iPad, and then in the top left-hand corner, it says Library. You should have two books in your library. The first book is the laws and rules.
Do you have a page number in the laws and rules?
Should be page 1.
Oh, okay. Sorry. Could have told us. Base.
And has merged the laws and rules together, and he started with the AMC ones, so you'll find that it starts with part 4.
You're referring to paragraph 3 items, basically A through F are the functions that an appraisal management company provides. Okay. Well, here's my question. In Exhibit 4, paragraph 4, the affidavit of Eric Sargent, if you look at the second sentence, in the spring of 2012, etc., basically, as I understand it, Mr. Sargent was informed by the lender, Southwest Funding, that this was the new appraisal management company. Did you receive anything from Mr. Sargent?
Sorry.
I'm sorry.
Could you repeat what section?
Sure. Exhibit 4, paragraph 4,
Okay.
second sentence. That's where Mr. Sargent describes how he came about being acquainted with the respondent. And I guess my question is this. Was Mr. Sargent asked, or did he supply any orders from the respondent? Was there any communication between the respondent and Mr. Sargent ordering appraisals or notifying him that they were the new appraisal management company? Or is the only communication between the respondent and Mr. Sargent purely the notice from the lender that they had switched companies?
I don't know if I can testify on behalf of another witness.
Okay. So beyond paragraph 4, that's all we have as far as the communication between the respondent and Mr. Sargent. Is that correct?
His affidavit is his affidavit.
Okay.
I can't testify on his behalf.
Sure. There is no other information or correspondence with the respondent than what we have in these exhibits. Is that correct?
Everything that he has provided is included.
Thank you. I have no further questions, Your Honor. Any other questions from commissioners?
Thank you so much for your testimony. Did you have additional live witnesses or additional affidavits or additional proof, Mr. Joseph? Would you like to make a closing argument? Will you have a proposed order for the commissioners?
Your Honor.
Okay.
If I may beg the court's indulgence, could we take about a 5 or 10 minute break
Sure.
before we enter the next
Okay.
phase?
Sure,
Okay.
that'll be fine. We
Thank
stand
you.
in recess for 10 minutes.
Thank you.
Record with a closing argument.
he listed his invoices to the Southwest Funding. Lack of information for a specific mailing address. Clear that the respondent did act as an appraisal management company in Tennessee as to these 7 pay these appraisals, pay the complainant for the appraisals as he's required to under Tennessee Code annotated. Acting as an appraisal management company in as much as it was to cooperate with the state according to the state's proof and would not give any further information. Violation of the state statutory scheme with respect to state's prayer in this matter for a appraisal management company without being registered is $5,000 per month, less than a $1,000 civil penalty per day. State's prayer for $12,000 for failing to pay Mr. Sargent the amount 12-month period in which the invoices were due from June of 2012 through and the $1,000 civil penalty for improperly removing Mr. Sargent. Respondent, we don't know what the but the respondent has chosen not to participate. In this case, the state would submit that we have adequately proven the respondent has violated the Tennessee Code annotation. I'd like to point out one typographical error in numbered paragraph 3.
Would you like to distribute those proposed orders at this time? All right, I'll permit the commission a few minutes to look at the proposed order before I give the charge. The Commission has now heard the proof in the case of Appraisal Valuation Services, docket number 12.36-121803A. The respondent, Appraisal Valuation Services, is before you for alleged violations of the Tennessee Appraisal Management Company Registration and Regulation Act, TCA 62-39-401 et sec. In particular, TCA Section 62-39-403A concerning the registration requirement, TCA 62-39-421 concerning payment deadlines to appraisers, TCA 62-39-424 concerning removal of an appraiser from an appraisal panel, and TCA 62-39-425, which sets out grounds for censure, suspicion of or revocation of registration. TCA 56-1-308A describes the civil penalties of up to $1,000, which may be assessed with each day of continued violation constituting a separate violation. Rule 1255-08-.07, 1, 2, and 3 provide a schedule of penalties. TCA 56-1-311A and Rule 0780-05-.11-.011 allow this commission to assess investigatory and hearing costs should you see fit. As sole and exclusive finder of facts in this matter, you must conduct open deliberations and make findings of fact and reach conclusions of law based on the facts found. Your findings of fact must be based solely upon the evidence presented to you in this hearing. The evidence includes the testimony of witnesses as well as the exhibits that have been introduced. The notice of hearing and proposed order filed by the state are not evidence, but may be used as a guide to assist you in making your findings, but it's the sole responsibility of the commission to make its own findings in this matter. The state's attorney has argued his respective theory of the matter. The statements of counsel are not evidence, but are merely arguments to persuade you to see the evidence in the light most favorable to their position. Give such statements whatever, if any, consideration you feel is appropriate. In making your findings, the commission must make the determination as to the credibility and weight to be given to the evidence presented by each witness. If there's conflict in the testimony between witnesses, it is the responsibility of the commission to reconcile those conflicts if possible. But if it is impossible to reconcile the conflicts between the witnesses, the commission must determine which witness's testimony to give the most credibility. In reaching such a determination, the commission should bear in mind the following principles of law. The law presumes that all witnesses who are sworn to the oath testify to the truth, It is the obligation of the triers of fact to attempt to reconcile any discrepancies in the testimony between witnesses, but if this is impossible, it is necessary for the triers of fact to determine which witness speaks the truth and which witness has stated a falsehood despite his or her oath. In determining which witness is believable, the commission as fact finder has wide discretion. However, the commission should consider in determining the truth the witness's interest, if any, in the outcome of the matter, their good intentions, their seeming honesty, their respective opportunities for personal knowledge of the facts about which they are testifying, and their conduct and demeanor on the witness stand. If the commission finds it helpful, it may weigh the evidence mentally on the scales of justice. If the scales tip in favor of the state, the commission must find for the state. If the scales tip in favor of the respondent, the commission must find for the respondent. If the scales are evenly balanced, the commission should bear in mind that the state has the burden to prove that the discipline or civil penalties sought are warranted. After a full and impartial review of the evidence presented to you, the commission may find, for example, that no violation occurred. It could find that violations occurred but that no penalty should be imposed. It could find that a violation occurred and that the state's proposed civil penalty is too high or it's too low. That a violation occurred and that the penalty the state seeks is proper. The appropriateness of the penalty may include consideration of a number of factors, for example, whether the amount imposed will be a substantial economic deterrent to the violator, the circumstances leading to the violation, the severity of the violation or risk of harm to the public, the economic benefits gained by the violator as a result of noncompliance, and the overall interest of the public. In assessing violations or a violation, the commission may consider any evidence that the parties have introduced, including but not limited to whether the conduct was or is of a continuing nature or a one-time occurrence. Additionally, the commission may also consider what it has done in previous similar matters for comparison purposes. You must also indicate a policy reason for your decision. It is improper for the administrative judge to participate in the commission's debate and deliberations because it's the commission's sole responsibility and duty to determine the findings of fact, conclusions of law, and policy reason for your decision in this matter. I will, however, be available to answer any legal questions on the record that may arise. Chairperson Green, please proceed with the deliberative process.
Thank you, Your Honor. If it's the commission's favor, I would propose that we evaluate each finding of fact provided us in the state's proposed findings of fact, item number by item number. We would entertain a motion and a second, and then discussion on each of the proposed findings of fact, and that would be the first phase. The second phase would be to incorporate these findings of fact with the portions of the law in order to tie the findings of fact to the conclusions of law. Is there any opposition to that procedure? Okay, hearing none, that's how we'll proceed. So, beginning with the item number 1 under proposed findings of fact, do I hear a motion in this regard? And when you state your motion, please read the finding of fact. It'd be helpful to incorporate items 1 and 2. I think those are sufficient that we might be able to incorporate those perhaps if it's the commission's favor.
I recommend that we combine proposed findings of fact 1 and 2. The Department of Commerce and Insurance is the lawful agent through which the act is enforced in the appraisal management company registration issued by the Commission. The TCA 6239-4.
Okay, so do I hear your motion as being that we accept items 1 and 2 of the proposed findings of fact? Commissioner Point? Is that your motion?
It is.
It is. Do I hear a second? Okay, second by Dr. Barilla. All right, so there's a motion on the floor. Do we have discussion regarding items 1 or 2? Hearing none. All those in favor of accepting items 1 and 2, findings of fact, say aye.
Aye.
Any opposed? Okay, the motion carries. So we have found that the Department of Commerce and Insurance is the lawful agent through the act is enforced, and that they are authorized to bring this action. And secondly, we found that the respondent does not hold and has never held an appraisal management company registration issued. Okay, moving along to item number 3, finding of fact. I'll let you read that, and then if someone would like to make a motion regarding this finding of fact, we'll entertain that. Make the motion, if you could paraphrase the finding of fact, that would be helpful.
Not 3, 4, 5, and 6, aren't they all interrelated?
Yes, they are, but I would prefer we deal with them one at a time. Although I can't tell you what kind of motion to make, so if you'd like to make a motion regarding all of them, you can, but I think it's probably beneficial if we handle each one at a time.
Green, I would move that we accept item number 3, finding of fact, that the appraiser, Eric T. Sargent, was doing business with the respondent, and he submitted 7 appraisals without receiving payment through Southwest Funding as the lender, and the respondent as the management company. Although I do want to note that we do need to make a correction in there, that instead of Mr. Taylor's 7 unpaid invoices, we do want to change that to Mr. Sargent's unpaid invoices.
Thank you, Commissioner Collinsworth. So we have a motion to accept item 3, finding of fact. Do we have a second?
Second.
Second from Ms. Johnson. Is there discussion?
Chairman,
Yes, sir.
I don't see where they were ordered by the respondent, as noted in number 3.
I concur.
Mr. Sargent's testimony, his affidavit, Exhibit 4, point 4. I trusted the instructions and the information given me by Southwest Funding, and I did not pursue the question of this respondent's registration or licensure any further. So I'm not, I think with he worked on the good faith of Southwest Funding, but I don't think he ever got the dots connected to what he was supposed to get done. I think maybe his evaluation might have looked at registering her and said it might not be financially worthwhile for them at the time.
Perhaps the agreement between Southwest and Appraisal Valuation Services never even got ratified, something to that effect.
It could be, but I think when I looked at number 4, know, you made a good point, good question earlier, and when I looked at number 4, and I don't affidavit that they were ordered by the respondent.
Other comments in that regard?
Other than in item number 3, it does say he was doing business with the respondent. Assume that's who he was going through, or?
Yeah, but then the last sentence there, the history of my involvement is recited below. And in the history of his involvement it didn't seem like it included ever being hired by them. Unless I'm missing something.
I think it's
He got
interesting.
everything there except something that said, I was hired by them to do this. He doesn't testify to that anywhere.
I think it's informative too. If you look at Exhibit 5, it's a collective Exhibit 5, and you look at the actual invoices, the only thing tying the appraiser's work, the complainant's work to AVS, if you will, Appraisal Valuation Services, is the name on the top of the invoice. Looks to me like he's still, and it could be, admittedly, it could be because he couldn't get an address, he couldn't get a contact from the respondent, but it's still back to Southwest Funding, their address. So I think that is of note.
Typically speaking, for residential appraisals on the secondary market, they'll still list Southwest Funding as the client, and the appraisal management company serves as an agent of the client. So Southwest Funding would still be listed as the client with their information. That's why you see Appraisal Valuation Services listed above Southwest. Although Southwest is the client of the report, Appraisal Valuation Services is acting as the agent only. That's why there's no other information provided in, at least on the invoices for that part.
Well, and that's a question, and I realize you're not a witness here, but is that common practice do residential appraisers accept with no other direction than what Mr. Sargent indicates? Is it common just to accept and keep working and not ever establish a formal relationship?
They're not allowed to.
Microphone. Does your microphone light up? Talk into it. There you go.
Typically, you're not allowed to have a conversation with a banker or a lot of people within these companies. It's just not allowed.
But I'm asking, it would seem to me that the appraiser would want to have a relationship with
The management company?
with appraisal valuations, or get clear direction that yes, you are the new management company, and yes, you will be ordering, and yes, you will be paying.
Without us not seeing the entire report, because you would hope there would be some form of an engagement letter or order form that came through Appraisal Valuation Services listing Southwest Funding as the client. Therefore, you know he's corresponding with Appraisal Valuation Services on behalf of Southwest Funding, on their behalf. Of course, we don't see the entire appraisal, so we don't see that part of it.
On the last page of the URAR, there is a place for not only the client, the company name, but the name of the
AMC.
appraisal management company.
But are you pulling that from some exhibit?
No, I'm pulling that from the ones I will do this afternoon, just so you could see. There's a spot for them on the
The
report.
Fannie Mae form. Yeah, the Fannie Mae form does allow for that.
Yes.
But without us having the entire report to review, we don't
There's
see
nothing
that.
in evidence to suggest that that's the case here, unfortunately. So-
Other than those invoices, but it doesn't specifically state that.
Well, let's gray this up a little further. if you look at the definition of appraisal management services, and I'm referring to paragraph 3, and here's where it gets gray. It says appraisal management services means to directly, and here we go, or indirectly perform any of the following. So I think we have, it's my personal opinion that we have indirect evidence that they were doing all these things. And that's, I think that's important here. We don't have direct evidence, but we have indirect evidence that would suggest that they are receiving orders, that they are tracking and determining. And Sergeant would, his affidavit, which we have to take as honest and factual, suggests that they were acting in this regard. But Commissioner Stanifer, we haven't heard from you yet.
$3 or that check have been from Southwest Funding or from Appraisal Valuation Services, just as a
What are you referring to? Which exhibit?
it's under the invoices, and he's got a here a paid.
This is Collective 5, Exhibit 5.
It is.
Okay, thank you. Okay, paid 403. This is, you're referring to the second invoice in that exhibit.
Yes, sir.
Paid 403.
Doesn't say who that came from.
All right. But where were you headed with that?
Is that relevant if it was, the check was from Southwest Funding? I mean, I don't know. I'm not real knowledgeable about management companies, but do you typically get the check from the lender or from the management company? Who issues the check and whose name is it in?
Typically speaking, it would come from the appraisal management company. Secondary market's a little different from in-house, so they have a little more flexibility, and I'm not completely aware of all of that flexibility. Typically speaking, the management company pays the appraisers.
Check would have been issued from, in conversation purposes, typically would be issued from Appraisal Valuation Services.
It would have been helpful for him to have included a copy of that check. I did note, Dr. Barilla, based on your point, item number 4 of Exhibit 4, he does indicate in here that Southwest Funding indicated to him they changed the way that they did their business, and they required that he work through that appraisal management company going forward.
Johnson? No comments? Okay. Any other conversation before we vote on the motion? And this is, just to refresh, this is proposed finding of fact number 3. And the motion was to accept it as a finding of fact, and it's been seconded. We've had conversation. So if there's any other comments, I'll hear those. Otherwise, I'll put it up to the commission for a vote. Any other comments? Hearing none. All those in favor of accepting item 3 as a finding of fact, say aye.
Aye.
So that was, let's do it by voice.
Aye, Eric Collinsworth.
Aye.
Can I have just a second, please?
Yes.
A.
I vote nay as well, but the motion carries, if I'm not mistaken, does it not? Correct. Okay, so the motion carries to accept item 3 as a finding of fact. Okay, moving along to item number 4. I'll let you read it and then entertain a motion as to whether item 4 is indeed a finding of fact. I have a motion as to accepting this or not accepting this or even modifying this as a finding of fact. Okay, well, hearing no motion, let's discuss item number 4, and perhaps we'll generate a motion. Commissioner Collinsworth, would you like to go first?
Well, in this case, and this is in regards to item number 4, him being removed from their approved appraiser panel, I don't see anything that's been admitted showing that he literally was removed. Some sort of a failed attempt on the website, printing the screen, something to that effect possibly. But at this point, I'm assuming he's making the statement himself, but I'm not seeing any proof in here of that.
In the first sentence, do we know that he was directed by respondent to submit his payment through e-bill pay? Know that to be a fact?
He testified to it. That's all.
So that's in his affidavit.
Yeah, that's number 7, I think.
Okay.
6, 8. I accept his testimony in that regard.
So the fact that he was initially on the list is based on that entirely? Is there any written documentation?
He just testified to that, I believe. It's entirely possible that they decided that they weren't going to register in Tennessee, and
Again, Doctor, where does he testify that about the e-bill pay?
number 8.
Exhibit 8?
Number 8 of page 2 of Exhibit 4.
Exhibit 4, number 8.
As directed by the respondent.
I see. Okay. All right. Okay.
By them to do this, but in number 4, he's testifying that he was instructed by them to submit invoices.
Right, and that's in evidence. Okay.
Yeah, that's his testimony.
Okay, so we feel confident then about e-bill pay based upon the testimony of the complainant. And basically the rest of this paragraph would follow along the same line of logic. So I guess if it seems like it would condense to, if we have confidence in his affidavit, then we would seem to have confidence in this finding of fact. So a motion in that regard might be helpful.
Based upon the affidavit of Mr. Sargent, I would make a motion that we accept the fact finding number 4, that he did make an effort to be paid through ebillpay.us and have his invoices paid. That he was, based upon his affidavit, that he was removed from the approved appraiser panel.
We have a motion to accept finding of fact number 4. Do we have a second?
Second that.
Okay, a second from Dr. Barilla. Is there further conversation or comments? Okay, hearing none. All those in favor of the motion, say aye.
Aye.
Any opposed? Hearing none, the motion passes to accept item number 4 as a finding of fact. Okay, item number 5, finding of fact number 5. There was no mutually agreed upon alternative payment schedule between respondent and Mr. Sargent, allowing respondent to take longer than 60 days. And respondent made no allegation that Mr. Sargent committed a breach of contract or provided substandard services. Motion to accept or move to accept by Dr. Barilla. A second? Second from Ms. Johnson. Conversation, comments?
Letter, or is this done totally by the email and phone? And what's the landscape for this?
Typically, you would receive some form of an email order.
Authorization to
right,
proceed.
If not necessarily a direct engagement letter, at least some form of an email engaging you. That would act as your order form, if nothing else.
You have nothing of that nature in the proof? It's just totally based on his word? Is that what I'm hearing?
That's what I was mentioning earlier.
He's given a sworn affidavit that should be,
had received the entire appraisals or something to that effect, then that might give us a little further support that they were directly the ones engaging him on behalf of Southwest Funding.
And I think it's important to note that the state has tried repeatedly to contact the respondent, and the respondent has chosen not to engage, or I shouldn't use that terminology. The respondent has chosen not to respond. So, you know, the fact that it's not in evidence is not necessarily a weakness in the state's case, I don't think. It's just we have what we have. Does it make sense? To some degree, this kind of follows the same logic. If we believe the affidavit, then this would seem to hold true.
Correct.
Other comments from other commissioners? All right, so the motion on the floor is to accept item number 5 as fact, that there was no mutually agreed upon alternative payment schedule between respondent and Mr. Sargent, allowing respondent to take longer than 60 days to pay, and that respondent made no allegation that Mr. Sargent committed a breach of contract or provided substandard services. That's the motion to accept. We've had conversation. I'll put it to a vote. All those in favor of accepting, say aye.
Aye.
Any opposed? The motion carries. So, last proposed finding of fact is item number 6, that respondent performed appraisal management services and engaged in business as an AMC in 2012 as set forth above without first obtaining a registration to act as an AMC from this commission. Do I hear a motion?
So moved.
Motion from Commissioner Stanifer, a second?
I second.
Second from Commissioner Point. Any comments? Hearing none. All those in favor of accepting item 6 as a finding of fact, say aye.
Aye.
Any opposed?
Nay.
One opposed. Dr. Brill is opposed. Motion carries to accept item number 6 as a finding of fact. Very good. So, all items have been accepted as findings of fact. We've made one change, and that would be to paragraph number 3, in which Mr. Taylor is changed to Mr. Sargent. Now we enter the phase where we tie the findings of fact to conclusions of law. So, you have your conclusions of law stated, and those are these are in the state's proposed findings of fact and proposed conclusions of law. We're on page 3, and you'll see the statute numbers, beginning with 6239-403. So maybe let's go back and let's go to finding of fact number 1, in which we say that that the department is the lawful agent and the state is authorized to bring this action. What is the Tennessee code that we can refer to here?
I think actually this item number 1 of proposed conclusions of law would best apply to item number 6 of the findings of fact.
Okay, we can do that. If you want to go take the statute and then tie it back to the finding of fact, that works for me, sure. So you're saying that Tennessee statute 6239-403 would apply to item 6, finding of fact, the registration requirement. Is that correct?
Yes.
Okay. Is there any other,
Also number 1. Department of Commerce and Insurance Division of Regulatory Boards is the law. Sorry. I believe this would also tie into proposed findings of fact number 1.
there you go, where it's, you must first obtain a registration issued by the commission. Okay. Okay. So, so would you say then, is there perhaps a motion to say that Tennessee Code 6239-403 was violated in findings of fact 1 and 6? Another motion.
Say I would move that it would apply to 1, 2, and 6 as proposed findings of fact. Item number 2 says respondent does not hold and has never held an AEMC registration issued by the commission.
Are you making that as a motion?
Yes, that's a motion.
So the motion is that respondent has violated Code 6239-403, and the findings of fact that support that violation are findings of fact 1, 2, and 6. Is that correct?
Yes.
So there's the motion. Do I have a second?
Second the motion?
Thank you. A second. So we have a motion and a second. Is there discussion? Hearing none, put it to the vote before the commission. All those in favor say aye.
Aye.
Any opposed?
Nay.
Dr. Barilla is opposed. The ayes have it. The motion carries. So to restate, the respondent violated Tennessee Code 6239-403 in findings of fact 1, 2, and 6. All right. Next code, Tennessee Code 6239-421. That's regarding payment deadlines to appraisers. Are there findings of fact that would support violation of this code?
I move that items 3, 4, and 5 would all apply to payment deadlines to appraisers at 62-39-421 in this situation.
Motion to accept violation of Tennessee Code 6239-421 is proved by facts, findings of facts 3, 4, and 5. Is there a second? Second by Commissioner Point. Any conversation? Dr. Barilla?
Well, I just go back to the original lack of a offer and acceptance, I think, evidence
Or could you
Dr.
speak
Burrell?
louder?
I can't hear
Sorry?
you.
Could you speak louder?
Yeah, with regards to this, I just go back to the original, was there an offer and acceptance and a contract between the two of them, the appraiser and the appraisal management company, and, you know, locker room lawyer at all, but I don't have, like, I don't see the evidence there of that.
Right, even though you have the affidavit?
But the affidavit never says that he had an agreement with them.
Okay, all right.
You can apply a lot of it, perhaps.
Point well taken, yeah.
That's sort of where I'm stuck on is the whole, offer and accept.
For consideration of your question of whether or not he was actually doing business with the respondent, item 3 in his affidavit does say, during 2012, I was doing business with Respondent Appraisal Valuation Services, an entity that was engaged in doing in the business as an appraisal management company in Tennessee. Again, we're basing it on his affidavit.
Yeah, but then he's saying the history of my involvement is outlined below.
Right.
That's, you might have thought
His-
that they were doing business here and he was doing business with them, and maybe that wasn't necessarily.
Again, we're having to base it off of his affidavit and his word, and not anything from the respondent.
And I think that's important. That's, we have to weigh this based upon the facts that we have. And we have the facts before us, so any other comments from commissioners on the motion? And just to restate, the motion is the respondent violated 6239-421 payment deadlines to appraisers, and it's proven by finding of facts 3, 4, and 5. Any other comments before we take a vote? Commissioner Stanifer? All right. Let's put it to a vote then. All those in favor, say aye.
Aye.
Any opposed?
Nay.
Dr. Parrilla, motion carries, passes. So we have voted that respondent has violated Tennessee Code 6239-421, and it's proven in findings of fact 3, 4, and 5. All right. There's other findings of facts here, or I'm sorry, conclusions of law. The grounds for censure, suspension, and revocation. Tennessee Code 6239. This is item number 3 in your conclusions of law. Item number 4 regarding removal from an appraiser panel. Tennessee Code 6239-424. Those and see if you would like to make a motion. Do I hear a motion regarding whether findings of fact support violation of those Tennessee codes, Tennessee Code 6239, 425, and 424, grounds for censure and removal of an appraiser from an appraiser panel?
Item number 3, I make a motion that paragraphs 2 through 6 of the proposed findings of fact be tied in with TCA 6239.
Six.
2 through 6.
Okay. So is that the end of your motion?
Yes, sir.
Okay, so Tennessee Code, the motion is that Tennessee Code 6239, 425 was violated in the findings of fact items 2 through 6. Do I hear a second? I have a second for the motion on the floor? No second. Okay. All right. So let's have conversation in this regard. Let's start with Dr. Barilla. Let's reverse our order here.
Are we talking about 3 and 4?
Well, really just Tennessee Code, yeah, item 3.
I mean,
and
they're
you can
not registered here.
you can loop in number 4, sure.
Yeah, yeah, they're not registered here, so. Talking about revocation of registration for an AMC that's not registered.
Item number 3 doesn't apply because they're not registered. Hard to censure, suspend, or revoke when they're not registered in the first place, basically.
Yeah.
Is your thinking? Okay. Looks like, I think item 4 would apply just in the sense that he is licensed or certified in Tennessee. I think that's their point. So he's subject to but benefits from Tennessee laws. Any other comments? Commissioner Johnson?
I would make just one comment on number 3 there. The law says or impose administrative fines.
Okay.
So you have the option of imposing administrative fines even though they don't have a license. Whether that's an option you want to exercise, that's a matter for the commission.
Thank you, Your Honor. Yeah. Okay.
Are we through with discussion?
No, we're still discussing really items 3 and 4, and there is no motion on the table.
I'm in agreement with Dr. Brill on that it would be hard to censor, suspend, or revoke their registration if they're not registered already.
Okay. All right. Any other comments or I'll entertain a motion here regarding items 3 and 4, conclusions of law. And if I don't hear a motion, then we'll move on. So, is there a motion? Okay. Hearing none, we'll move on. Tennessee codes, let's be certain then. So Tennessee code 6239.425 and 6239.424, commission elects not to comment on. Item 5. Let's be clear. Commission has voted and approved code 403. Let's just skip to the last 3 digits for simplicity. 403 and 421, the commission has voted that they have violated. So 403 and 421. Reading item number 5. Amounts for assessment of civil penalties, 50 to 1,000 per separate violation. So I think this is where we would entertain a motion, basically summarizing, restating item number 5 perhaps, and clarifying the changes we need to make to item 5 in regard to respondents' violations. And this is, it's my understanding, this is going to tie into the judgment phase. So probably need a motion basically changing item 5 to reflect what we just did in terms of conclusions of law. Any of the commissioners like to take a crack at modifying item number 5? Yes, Commissioner Point.
Since we have eliminated 6239.425 and 6239, I recommend that we remove those 2 from item number.
Okay. So is it your motion to accept conclusion of law number 5, however, just deleting reference to statute 424 and 425?
Yes.
So that's your motion.
Yes, it is.
Okay. Do I hear a second?
I'll second the motion.
Second from Commissioner Stanfer. Comments?
Really, I mean, is that
Well,
one sort
you
of
should
missing-
probably, for the record, you should probably say it.
One missing piece of evidence that I said before is I don't see what. Trusted the instruction and information given to him by Southwest Funding. So it doesn't, I mean, he trusted their information and did the work, but he never says that.
Thank you. Any other comments from other commissioners? All right, hearing none, we'll vote on the motion. Motion is to accept item number 5, which is a conclusion of law, with the deletion of the statutes ending in 424 and 425. That would be 6239 424 and 6239 425. That's the motion, and there's been a second. We've had conversation. All those in favor, say aye.
Aye.
All those opposed?
Hey,
Dr. Brillo opposed. The motion carries. Okay, we're entering the next phase, which, Your Honor, if I'm not mistaken, is to
Find out whether or not fines or other disciplinary action are in order.
okay, all right, based upon our conclusions of law and findings of fact. Sure, okay. All right, well, the state's been kind enough to provide a proposed judgment here. What do the commissioners think of this proposed judgment? Is you can accept it, you can reject it, or you can change it. So, whatever you'd like to do.
I would like to make a motion that we judgment that we adapt item A and B, but eliminate
We have a motion to accept proposed judgment, item number 1. So, in a second, a motion from Commissioner Standifer, a second from Commissioner Point, and that's to accept item number 1, A and B, but to delete item C. Is that the motion?
that is correct.
That's the motion, okay. Conversation? Okay, hearing none. All those in favor say aye.
Aye.
Any opposed?
hey,
Dr. Barilla? Motion carries. Regarding item number 2, motion regarding item number 2.
That we accept item number 2 as written. The respondent has assessed all investigatory and hearing costs as noted in.
Motion from Commissioner Point to accept item number 2 and a second by Commissioner Standifer. Any discussion? Hearing none. All those in favor say aye.
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 Any opposed? Motion carries unanimously. Okay. All right, Your Honor.
Need a policy reason for your decision.
I just happen to have that. Thank you. Just a second. Let me formulate that quick. Okay. The Tennessee Real Estate Appraisal Commission is charged with the duty to regulate the practice of real estate appraising in the state of Tennessee, such that the citizens of this state receive all such services in accordance with state law and regulations. because the respondent has violated the law and regulations governing the practice of real estate appraising, it is in the public interest of the citizens of this state and for the protection of their welfare that we have fined the respondent appraisal valuation services as voted on here today.
Vote on your policy decision, on your policy reason, or is it the practice of this commission?
It's the
not to
practice
take
of
a
the
vote on it?
commission not to vote. That's, yes, Your Honor.
Okay, all right. Well, then, this hearing is concluded. Thank you.
Thank you. Right. Well, next item on the agenda is a lunch break. So the commission meeting will be adjourned until 2 p.m., which is the conclusion of the experience interviews. So we'll be meeting back here at 2. Thank you.
Like going on vacation.
All right, this is the afternoon session of the September 16th, 2013 meeting of the Tennessee Real Estate Appraiser Commission. The next item on our agenda are the experience interviews, and the first commission member to report is Commissioner Nancy Point.
I had an experience interview this morning at 8 o'clock with Kathy Hall, and I would recommend that that she be moved from trainee to licensee so she can proceed on to take her exam and move forward toward becoming a licensed appraiser.
Okay, we have a motion to approve the upgrade. Do I have a second?
Second.
Second from Commissioner.
Walton.
Oh, thank you. It's been so long. Thank you. Thank you. Second from Commissioner Walton. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? Motion carries. Commissioner Hall unfortunately had a serious family matter come up, and so I understand that another commissioner has interviewed Pamela Mooneyham. Which commissioner was that? Or was it our director?
That was me.
Oh, okay. Very good.
I sat in this morning with Mr. Hall, and then he had to be excused early. And after our interview this morning, it was Pam Mooneyham that I interviewed this morning. And after the interview, it is my thoughts. I move that we would ask her to remain as a trainee and continue monitoring her experience, and ask her, I don't know the term limit, but maybe in 3 months, ask her to forward 3 additional new reports for review that we will pick after today's date, and monitor her experience from this level forward for over the next 3 months, and then see if she would be approvable.
Said additional reports from this day moving forward.
Yes, if she'll send us an experience, her experience file, her list, then we'll pick 3 appraisals from today forward. They will not be older appraisals, but after our interview today, we'll pick 3 new appraisals that were from today forward.
And she has as much time as she would like in order to acquire that experience to submit that
Sure.
log. Okay.
Sure.
Okay. I understand it. So we heard the motion to defer until we can review a later experience log. Is there a second?
Second.
Second from Commissioner Johnson. Any conversation? Okay, hearing none. All those in favor?
Aye.
Any opposed? Oh, motion passes. Next person on the trainee agenda is myself. I will turn the meeting over to Ms. Johnson.
Mr. Green interviewed Andrew Renfro.
I did. Mr. Renfro is seeking an upgrade from trainee to certified general. and I recommend in favor of the upgrade.
Second.
Okay, vote. Aye.
Aye. Okay, motion passes. Commissioner Point, you interviewed Thomas Hetrick.
I did, and I would recommend that he be allowed to upgrade and take his exam going from licensee to certified residential.
Is there a second? Second from Dr. Barilla. Any conversation? Hearing none, all in favor?
Aye.
Any opposed? None opposed. Next person on the trainee interview is Charles Conroy. He goes by Chase, and I conducted that interview. So, Ms. Johnson?
Okay, Mr. Green? Charles Conroe.
No problem. Once again, had a good interview with Mr. Conroy. He's seeking an upgrade from licensed appraiser to certified general, and I recommend in favor of the upgrade.
All in favor?
Aye.
Okay, hearing no opposition. Next commissioner to do an interview was Commissioner Collinsworth.
Yes, this afternoon I had an interview with Pamela Schoen, and she has applied to go from a trainee to a certified residential appraiser. She has already taken and passed her exam, and I move to recommend that we do allow her to move up to the certified residential designation.
Second from Dr. Barilla. Any conversation? Hearing none. All in favor say aye.
Aye.
Any opposed? Okay. Motion passes.
Mr. Green interviewed Richard Fowler.
I did. Mr. Fowler was seeking an upgrade from trainee to certified general. I have three recommendations. First, that Mr. Fowler submit an experience log from this point forward. Second, that the reports chosen for review should contain highest and best use analysis. And third, that the reports chosen for review contain processing of the income capitalization approach and the sales comparison approach. And fourth, that just for independence purposes, that another commissioner, another commercial appraiser conduct the second experience interview. So those are my recommendations.
Second.
All in favor of those recommendations?
Aye. Okay, hearing no opposition, last commissioner to report is Commissioner Walton.
All right, this afternoon I interviewed Mr. Otis Smith III, wanting to upgrade from trainee to licensed. We had kind of a hiccup in getting the reports. Inadvertently, I got 3 copies of the same appraisal. And actually, in our interview, we didn't even work all the way through that one appraisal. But having looked through it, I would like to request some additional appraisals from going from this day forward to review, and on defer judgment until we get a chance to review those.
How many additional reports?
I'd like to.
Is that the extent of your motion,
That is it.
Commissioner Walton? Okay, is there a second? Second by Dr. Barilla. All those in favor say aye.
Aye.
Any opposed? Motion passes. That concludes our experience reviews. The next item on the agenda is the application review process, and beginning with Reliable AMC, J. Kevin Stitt. Ms. Avers, would you like to take the meeting now in regard to Reliable AMC, J. Kevin Stitt?
Yes, sir. This is a reconsideration after additional information was requested during the July meeting. The first part is summarized from the July meeting regarding the appraisal management company, Reliable Appraisal Management Company, LLC, the controlling person, J. Kevin Stitt. All of the first page is just a summary which was presented during the July meeting. The second page, after item number 8, is the new information. And I believe Dennis has passed out for your review the additional information that they submitted. I'll just summarize. Scott Giselle requested an appointment to speak to the commission on behalf of Gateway Mortgage Group and Reliable Appraisal Management Company, LLC. The matter was presented July 8th, 2013 for applicant review. Mr. Giselle was present. Ms. Point moved to table a decision on granting the AMC license to Reliable AMC until he was able to furnish a background check information on the AMC controlling person, J. Kevin Stitt, and a copy of the errors and omissions insurance policy for the company. That was seconded by Ms. Johnson. As follow-up to the meeting, Reliable AMC provided a certificate of insurance showing RAM as the certificate holder and setting forth coverage limits, a copy of the application submitted as part of RAM's license approval in the state of Florida, which had included background information for Mr. Stitt and additional information on Mr. Stitt's community service. My recommendation is the application be approved. You've passed that information all out for them? That should be on your desktop.
There should be hard copy in everyone's place.
So, in review, the application was in question originally because some of the mortgage operations had lost their licensure. Is that correct? Is that what my memory is? He had affiliated mortgage companies, was that right? And their licensing had been revoked?
Been the controlling person for, does it say what it was?
Gateway?
Yeah,
Gateway?
Yeah, Gateway, you're right. Gateway Mortgage Group, LLC. And we had discussed in the last meeting some of the actions that had been taken against Gateway. I think there were probably 7 or 8 things listed there that we went into. And then you guys had requested additional information from him, and I think that's what she's presenting. So yes, you're correct.
Okay. And we don't feel like there's any surety bond or anything like that. I mean, at one point he had offered to post some kind of bond, but you're not recommending that, Ms. Avers?
It's not a requirement for any other AMC in Tennessee.
Okay. No
They
problem.
have a surety bond that they included with their application. An additional surety bond would be a requirement
Additional.
above and beyond the requirements of every other AMC.
Any conversation from commissioners? What about our AMC member?
I was looking at his liability insurance. He's got a $5 million Gateway.
Anything in his insurance that covers appraisers in the event he doesn't pay them? I'm just saying, because what we're talking about this morning.
Well, I think last year we had an issue with a company where their bond had expired or something, and they left a lot of appraisers hanging.
Yeah, and this morning we had one that wasn't licensed, and they didn't pay their bills. Okay. Any other comments from commissioners? Okay, well, would someone like to make a motion regarding the director's recommendation?
Make the motion that we accept the director's recommendation and approve.
Second? Second from Dr. Barilla. All those in favor say aye.
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 Any opposed? Motion passes. All right, the second item. Okay. All right. The next matter is an application review regarding Gary Lee Beaver, who, as your notes indicate, our director, take it from here. I'm not, I haven't read all these notes, so talk to us, Ms. Avers.
On August 1st, 2013, an application to become a certified general appraiser based on reciprocity with State of Georgia was received by staff from the applicant Gary Lee Beaver. Mr. Beaver also holds a credential in the state of South Carolina, which was granted through reciprocity. He previously held a credential in Colorado, which has been revoked in 2008, and a credential in New Mexico, which expired in 1999. The application was initially incomplete, and the applicant was given an opportunity to address the missing pages of the application and answer the required character question document request. The application included marking yes to character question number 1 on the application, which reads in part, have you ever been denied an appraiser license or certificate, or had an appraiser license or certificate or professional license of any type, disciplined in Tennessee or elsewhere? Mr. Beaver summarized his disciplinary history in a letter to the commission. He indicated that he had been disciplined in 1997, which involved an appraisal he signed as supervisor, which resulted in a $500 fine and a 15-hour USPAP course. He indicated he worked part-time in Colorado and part-time in Georgia, but for health reasons he decided to let the Colorado license expire. He indicated in May of 2008 someone filed a complaint against him, and the Colorado board requested response and audit of his continuing education. He indicated that he called the board office to notify them he would not be renewing and would not challenge the complaint. He indicated he gave him his Georgia and Florida addresses at that time. He concluded that in his letter that he had no further contact with Colorado and considered the matter closed. Colorado revoked his certification on August 8, 2008. South Carolina Appraisal Board reprimands licensees that are sanctioned in another state. South Carolina placed Mr. Beaver's certification on 2 years probation according to his letter, and the probation ended without incident. Mr. Beaver submitted a certification history from Georgia and South Carolina, included the South Carolina consent agreement from 2008. On August 14, 2013, Tennessee administrative staff contacted Colorado administrative offices and obtained copies of all prior orders relating to Mr. Gary Lee Beaver. There were more orders than originally described in Mr. Beaver's summary letter. He was notified by email August 30th of the additional order, and he called in and said he'd forgotten the order from 1997. He was informed by phone and email that he could get a copy of the documents if he requested, and was scheduled an appointment to discuss the application in Tennessee Commission. The allegations in the 2008 Colorado complaint included grossly inflating an appraisal of residential property, which resulted in financial injury to one or more parties, and which disposed of by revoking the appraiser credential when a notice of complaint letter was delivered, but the respondent did not accept delivery of the letter at the Colorado address or Florida address, but it did acknowledge a voicemail. He was disciplined in September 15, 2000 for failing to submit continuing education to Colorado when he was selected for audit during the renewal period of January 1st, 2000 to December 31st, 2002. He made applications stating under penalty of perjury in the second degree that he had complied with the continuing education requirements. He had also failed to complete the continuing education requirements in terms of prior agreement during the period of January 1st, 1997 to December 31st, 1999. According to the order, Mr. Beaver documented 15 hours completed after notice of audit after investigative contact. An additional final agency order executed December 30th, 1997. The respondent was disciplined for multiple violations of USPAP, including ethics provision noting the respondent acted in manners that were unlawful, unethical, and improper. The disposition included 2 years probation, $2,000 fine, all of which was stayed, but $500 and a 15-hour USPAP and 15 hours of report writing courses. The applicant has a disciplinary history in Colorado and South Carolina. Excuse me. South Carolina discipline was reciprocal discipline, resulting from the revocation. The applicant requested an opportunity to speak to the commission regarding medical history and his recent application. The applicant is not in good standing in Colorado, so the recommendation from staff is that the application be denied.
This gentleman here today?
Yes, he is.
Okay. All right. Is it the director's opinion that we should hear from the applicant? Okay. All right. Well, Mr. Beaver? State your name and your current address.
The table, if you'd like. So that we can get them.
Go ahead and state your full name and your current address, Mr. Beaver.
Sit here. You
Okay,
can sit here.
thank you.
Just speak into the mic.
Yes, it's Gary Lee Beaver. Address is 1105 Blythe Island Drive, that's Brunswick, Georgia, 31523.
Okay. Tell us why you're here.
Well, I had made first I had mentioned to staff that I had brought some appraisals that I'd done to demonstrate, that you could see, to demonstrate the type of work I do. And I had a couple of reference letters that I'd like to present to you as well, if I may.
Not at this time.
Okay. Well, I had made an application to, as Ms. Avers had indicated, that I had made an application to obtain a license in Tennessee. I've had a license in South Carolina from the very beginning. I'd gone to Colorado and had gotten a license out there and went into business. Subsequently, I had gotten a license in Georgia because I was working some out west and some back here. I had primarily worked on commercial appraisals back in South Carolina and Georgia, so there would be situations that I would come back and look at the property, and I was familiar. It was in an area that I had worked in for quite a while, so it was things that I had known and had familiarity with them. But and there had never been I had never had any issues at all other than Colorado. Now the South Carolina issue that the director mentioned was, the way they explained it to me, it was a procedural in that any time someone had a license in another state, another jurisdiction, and they have any issues, South Carolina essentially puts them on probation. And that's the way I understood it with regard to the South Carolina issue. other than that, I've had no issues with them. I've not had any issues in Georgia. You know, knock on wood. The business in Colorado. I did have my education. I've got a lot of education. I've got a lot of courses. I've supplied the board with a whole roster of courses, most of which are from Appraisal Institute, and I probably, in terms of me not supplying them with continuing education along, it was probably just sloppiness on my part in terms of that. To be quite frank, in terms of the issue that resulted in the revocation, there was a complaint brought against me. I found that out. I'd been in communication with the folks in Colorado. I had had a phone conversation with them, and I'd asked them to please send any correspondence to me at the Georgia address, because I did have a Florida address, I did have a Georgia address, and they had the Florida address on file. The Georgia address they didn't have. Well, they had I presume they had it, but I told them, please send any correspondence to me at Georgia, because I was no longer in Colorado. I was no longer in Florida. I did have some pretty severe health issues. I had 2007, I believe, 2007. It was I had inflammation in my heart was the diagnosis, as a term for it. I can't recall the name of it, but I was also, the doctor described it, some of the kind of issues with brain cells that were of a similar nature. Plaque buildup in and around the heart, and plaque buildup in and around the brain. But it was very during that time, it was very difficult for me to function, and in fact, if I were to walk to the front door of this building, I wouldn't be able to do it without. At that point, I wasn't able to even do that without being out of breath and maybe, you know, having to brace myself against a wall or whatever in order to go and come back. That being said, when the business with Colorado came up, I had told them I would. You know, I was not going to renew the license, that could be reached in Georgia, and I think they according to the information there, they sent the correspondence to Florida, which I never did get. So it wasn't I didn't receive it, didn't accept it. It didn't come to me where I was. Now, I was remiss in not writing to them and putting it in writing. I realize that in hindsight, but it was not. I understood from having talked with those folks that it was all right, that they had made a note of it and they would send me the information. In fact, I didn't even know the disposition of that until I was contacted by South Carolina with regard to their action. I'd gotten a letter from them, so I called them and asked them about it, and the leader asked me some questions, and I answered her questions. So I didn't just refuse to contact them or refuse to cooperate with them. It was just that correspondence went to where I wasn't getting mail. I mean, I wasn't physically in Florida. I was in Georgia.
Thank you. Anything else, Mr. Beaver?
Other than that, I've not had any like I say, knock on wood, I've had no issues with regard to any license, and I've had appraisal license since day one. And other than that, I don't know what else I'll be happy to answer any questions.
Sure. Thank you. Commissioners, questions for Mr. Beaver? Anyone? Thank you, Mr. Beaver. All right. Well,
would anyone like to see the information that I have?
Not at this time. Thank you. All right, well, you've heard the director's recommendation. I would entertain a motion as to the director's recommendation, and you've heard Mr. Beaver's comments. Is there a motion? Would the commission like to discuss this?
Table this and have some time to look over it. I mean, this is the first time I've seen this.
Absolutely, sure. Let's look at our agenda here. Tell you what, let's take a 10-minute break. And is that enough, Commissioner Point?
I was going to say to another meeting.
Okay. Would you like to put that in the form of a motion?
I would like to make a motion that we hold this over to the next meeting and give us some time for consideration.
Okay. There's a motion on the floor by Commissioner Point to take this up at our next meeting. Do I hear a second?
Second.
Second. Any conversation or discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? Motion passes. Mr. Beaver, we'll defer this till our next meeting. You're welcome to attend. We probably won't solicit comments from you at that time.
May I leave the paperwork that I brought?
Welcome to leave anything you'd like. Absolutely.
I would like to leave it. I mean, it's nice work. And
Sure. I don't think that's the question before the commission, though. It's a function of your licensing history and what's of public record in regard to your disciplinary history.
I can understand that. I know you're responsible to make sure that you grant you got a fiduciary responsibility. I know that, to make sure that people you license are worthy of that license. And in my instance, I mean, you don't know me from Adam, but a lot of this, the way it sounds like I was just a bad guy. I mean, if I read that and I was in your position, there's no way in the world I'd give me a license. I mean, I wouldn't.
Right.
But I'm going to be quite frank with you. I have tried to do this work and do it as responsibly as I can in terms of giving good quality work and doing the things I'm supposed to do. I've taken the classes religiously over the years, and again, it very well may have been that I didn't submit the paperwork like I'm not. The one thing that I'm not real good at sometimes is administrative things and paperwork. And I'm not good at that, and I probably didn't follow through that when she mentioned back in 2000. I'd forgotten all about that, or I would have mentioned it. But
I hate to cut you short, and I
know
can appreciate it.
You got to go.
Yeah, we really need to move on. I think the commission has the facts that they will weigh this decision based upon. I can appreciate your conversation, and I can appreciate your defense.
Anything I can do that would, other than me just trying to offer an explanation that would
Well,
perhaps make you think that I'm not a bad guy.
Sure. If there is, Ms. Avers will direct you as to what those things are. So at this point, I need to thank you, and we need to move on.
Thank you for your consideration.
You're welcome. Thank you,
For
sir.
the question? I don't think you voted on it.
Yes, we did.
Did?
Yes, the motion
I
was the motion was to table it to the next meeting.
I thought it was just motion and seconded. I'm sorry.
Well, should I talk to them about the stuff that I brought, or is that?
Oh, Miss Avers will ask you if there's additional information we need.
Hey, do I need to find that out now, or ask, is that gonna be something that comes up later?
No, she'll be in touch.
Okay.
Yeah.
Oh, okay. All right, well, I guess I can leave.
Well, Miss Avers, do you have additional information you'd like to receive from Mr. Beavers?
I have no information additionally requested. The information in the packet that you was passed out is time sequential, so you can see the information he provided to us and then the additional information we received from Colorado.
Well, let's be clear. Is there any question about the quality of Mr. Beavers' work? That isn't the question here, is it?
We don't normally solicit experience reviews from reciprocal applicants. It's not unheard of. We've done experience interviews with out-of-state applicants before, but it's been a number of years since the last time it was done.
Let me add one more thing, and I'll be real fast. My intention was to go to work in Kingsport for Henry Bailey, and working under his office at his direction. I don't do administrative things well. I don't do them well, I promise you. But I don't want to put myself in that position, because I know my weaknesses, and that I have no intention of being on my own business up here. But even if it was some kind of probationary license you could give me for a while, just where you feel better about it. I don't know what you can do, what you can't do, but I'm honestly, I like him. I think I'd like to work with him, and I know he's been in business a long time, and I believe he would keep me on the straight and narrow if there was anything that, and I wouldn't do it. I don't do this stuff. I do it for money, because we all work for money, but I like the work. I like the work I enjoy doing the appraisal work. So
Thank you, Mr. Beavers. We'll keep that in mind.
All right.
Thank you, sir.
All right.
Yes, sir.
Henry Bailey did speak very highly of the work that
So is Mr. Beavers acting as an appraiser in Tennessee without a license?
I don't know.
Well, how could he comment on his work product if he didn't do appraisal work? Is he working for Mr. Bailey in Tennessee or not?
That I don't know. He just said he was coming up for it.
He's probably speaking of information I sent to him. I haven't, he's not employed me to, I'm not under his employ at this point, but he had conversations with him and so forth, but.
Possibly send him some examples of your work
Right.
product.
Right.
Well, if you're going to supply Ms. Avers with any information, I'd like you to supply her with any appraisal work you've done in Tennessee in the last 3 years. Okay?
I haven't done any appraisal work in Tennessee, because I don't have a license in Tennessee.
Okay, no problem. Thank you.
Sure.
All right. We will take a 10-minute recess. Or do we need one? I'm sorry. We've already tabled. You still want? We've tabled it to the next meeting. We don't need a recess. I'm sorry. Wait a minute. Yeah, let's finish.
Dennis, we're not taking a recess, I don't think.
We're not going to take a recess, Dennis. The other Dennis. So Dennis, you can leave it running.
Let's leave it with Dennis here.
Okay. So back in session. All right. The next item on the agenda is the legal report.
More confusing.
Be all right, Ms. Keeling.
Hold on just 1 second. We're looking for another hard copy of the legal report.
Okay.
Did you? Where is it?
We can share if you
No, it's fine. I need something to take notes on.
Just make a copy of this.
Never mind. It's just buried. There's a lot of paper over here, and there's been a trial or a formal hearing since then. I'm good. Thank you.
Ms. Baird.
Okay. Item number 1 on the legal report, 2013007651. I'm going to request that we defer this one until the next meeting. I had already put it on the legal report when I found out that we had an incorrect address for the respondent and she didn't actually receive my request for a response until Friday. So she hasn't had the 10 days to respond, and so we should probably defer that one.
No problem.
Okay, item number 2, 2013000851. Complaint was filed by a consumer and alleged that respondent failed to employ recognized methods and techniques in the appraisal of a property for the market value of a pipeline estimate in May 2006 with regards to the damage to the remainder and the cost to cure. In addition, the complaint alleged that respondent failed to appropriately report these to a federal court, which the complainant alleged caused significant reduction in the settlement. Respondent acknowledged completing an appraisal on the subject property in his response to the complaint and indicated that a gas company was installing a natural gas transmission line across multiple properties in the northern portion of the county. Respondent's client was the attorney for the complainant. In response to the allegations in the complaint, respondent acknowledged that he was paid by the complainant for the first appraisal report. He then updated the report at no charge. Respondent acknowledged that he provided complainant's attorney with an appraisal report dated September 29, 2008 on complainant's property, and then provided an updated report dated August 25, 2010. The attorney requested the update after a conversation with regard to the date of taking and meeting the spirit of the federal rule. The updated report reflected the new established date of taking by the federal court to follow the spirit of the federal before and after rule. Respondent denies the claim that complainant makes, which is the focus of this complaint, that the inclusion of the cost to cure items into one damage factor caused complainant to have his settlement limited. Respondent indicated that complainant is operating under the assumption the cost to cure items would be allowed by the federal court if presented with only the first appraisal, and he would receive all or a portion of the cost to cure. There are no facts to support this complaint, according to respondent. Respondent claims that the facts do not support complainant's claim that the respondent appraiser is responsible for him receiving less of a settlement than he wanted, and that the complainant is passionate about his position of not wanting the pipeline across his property, and his personal position is that he is due extraordinary damages to the remainder of his property as a result of the taking and construction. The reviewer's conclusions are listed there. The appraisal originally developed the appraisal following the state rule. In the court proceedings, the judge required the appraiser to employ the federal rule, which is fundamentally different. The state rule permits evaluation of the total property, the part acquired, and any offsetting damages and or benefits to the remainder. The federal rule requires valuation of the property before acquisition and valuation of the property after acquisition. In the reviewer's opinion, the respondent's actions, which complainant considered a mistake, were the result of the judicial decision, and the reviewer does not find the complaint to be valid. In the reviewer's opinion, the respondent provided 2 reports that were accurate and in compliance with the USPAP. The respondent provided adequate and relevant data and the propriety of any judgment to the data. The reviewer did not find any USPAP violations in either report and found that respondent utilized recognized methods and techniques. Based upon the reviewer's review and analysis, he concluded the appraiser is in substantial compliance with the minimum standards of USPAP. Respondent indicated rights appraised as fee simple and did not state easement interests as interest appraised. Other portions of the report make it clear that he was appraising the easement interests. Thus, the reviewer recommended that the complaint be dismissed based on the summary and conclusions for the review report. So based on the reviewer's report, counsel recommends this matter be closed with no further action.
Okay, in regard to complaint number 2, do we hear a motion?
Make a motion that we accept the recommendation of legal counsel.
Second.
Motion by Commissioner Walton, second by Commissioner Johnson. Any discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion passes.
Okay, item number 3, there are 2 items on this number. These are both the same respondent. It's 2012-011061 and 2012011771. And just before we get to the recommendation, so that nobody's confused, the intention was to combine both of these into one disciplinary action since it is the same respondent. So just keep that in mind as we're going along. Complaint was filed, this is 2012011061. The complaint was filed by a mortgage lender who appears to be the purchaser of the loan in this matter and alleged mortgage fraud on the part of respondent by inflating the property value by 40% or $40,000. The complaint alleged that as a result of this activity, the mortgage loan went into default. Respondent sent a response to the complaint stating that she did not do an appraisal for the mortgage lender who was the complainant in this matter, as she was not on their approved list. Respondent claimed she did not inflate any value, nor did she commit mortgage fraud. In her sales comparison approach, she utilized 2 sales that were in the immediate area and substantiated the value conclusion. Respondent suggested that the value for the site value opinion was based on the extraction method, based on the sales price, then taking the cost of the improvements less depreciation, then subtracting this amount from the price, giving you the site value. And I've listed the expert reviewer's conclusions there, if you guys just want to read over those, if you have any questions. And also, the respondent was given the opportunity to respond to these reviewers' conclusions. However, we didn't receive a response from the respondent. So if you want to take a minute to look those over.
What year was the appraisal completed? Can you tell us that?
If you look down in the disciplinary history section, it says that this complaint is from November 25th, 2008. I can look it up in the file and get you the exact date if you want that.
That is the exact date.
And that is the exact date. While you guys are doing that, I'm going to go through the second complaint that's part of this. That way we can look at it as a whole. It's 2012011771. This one's a lot similar to the previous complaint. Was also filed by a mortgage lender. An alleged mortgage fraud on the part of respondent by inflating the property value by 57.69% or $37,500. Complainant lender is no longer servicing the loan. Again, the respondent sent a response to the complaint stating she did not do an appraisal for the mortgage lender, who is the complainant in this matter. She was not on their approved list. Therefore, complainant had no right to use her appraisal. Respondent claimed she did not inflate any value, nor did she commit mortgage fraud. Respondent claimed that all 3 of her sales were taken from the immediate area and interior photos were included to show that the subject was not in disrepair. The subject was under contract for $50,000 with a gift equity of $13,425.15. Respondent stated in her response that the cost approach information included is from a later date than what was on the original appraisal due to a fire she sustained at her home in February of 2009. Some of her work files were lost in this fire. The value for the site value opinion was based again on the extraction method, based on the sales price, then taking the cost of the improvements, less depreciation, then subtracting this amount from the price, giving you the site value. And again, the reviewer conclusions are listed here. The respondent also did not file a response to the reviewer's conclusions in this matter. And you can also note in the disciplinary history, this one is also from 2008.
A question for Ms. Avers. Does this respondent have registered trainees currently?
I don't think so, but I don't really know. They're out of state. Ended until recently, so I don't think they do, but they are reciprocal. Might have trainees in another state.
They were suspended in Tennessee until recently, or in their home state?
They were suspended in Tennessee.
There's sort of like a little brief thing in the disciplinary history that we tried to explain, but yeah, it was here.
It was here. They were suspended for
438 days.
For failure to comply with the terms of the prior consent order.
But we have conversation and discussion about this, and then we entertain a motion. Are there other comments or questions? Okay, would someone like to make a motion regarding council's suggested disciplinary action and fine?
I would like to make a motion that we fine the person $5,000 instead of $1,000. 2 years of probationary period in which they have to turn in files and be reviewed. And do this within the period, the 2-year probationary period. But
How about trainees?
no trainees.
And no trainees. And what happens if they don't comply with these?
Their license would be revoked.
Motion is a, did you say 5 or 2?
$5,000.
Motion is a $5,000 fine, a 2-year probationary period, no trainees, and in the event of noncompliance, revocation. Do I hear a second?
Can I ask one question real quick in regards to the disciplinary history previous? It said a $500 civil penalty, a 30-hour basic appraisal procedures course, and 15-hour, and then the 438-day suspension. So I'm assuming that this appraiser did do the 30-hour basic and the 15-hour during that period.
Yes, the courses were recently submitted to comply with the terms of consent.
Let's hold any further questions or comments till we entertain a second to.
I'll second her
Okay, so we have
motion
a second from.
Also, I have a question, and it might be common knowledge, but should we specify how often we want this information turned in to be reviewed. I mean, I'll have to probably put that in the consent order, so for specification purposes for me.
We need, how
Every
often?
6 months?
Every 6 months for 2 years.
Yes, ma'am.
Okay, so you're amending your motion then? Okay, are you,
I'll still second her motion that
Okay.
it would be every 6 months.
everybody hear that? All right. Any other comments?
I just want to clarify, all right, we had the first consent order, and that was history, and that was something that had already been dealt with. But it took them 480-something days to comply with the original consent order. On the heels of them meeting those requirements, we had another a complaint filed.
The complaint was filed during the suspension.
During the suspension.
They were aware.
That the complaint was suspended.
This wasn't something that was filed yesterday. It was during the time when all of this other stuff was.
Kind of on hold while she was on suspension. Now coming off suspension, it's time to deal with the second complaint. And we're dealing only with the second complaint.
Those complaints,
Yeah,
there's
the
two
two that we
complaints.
have combined in this one disciplinary action that we're talking about now. There are 2 different complaints combined into one here.
So the first disciplinary action was
Third
on a
complaint.
third complaint way back.
Correct. Yes.
Okay.
Is it possible to read the motion again? Can you do that, Savers?
Notes I have is for a $5,000 civil penalty to be satisfied within 30 days of execution and a 2-year probationary period during which they will have to, the respondent would have to submit an experience log every 6 months, and experience reports would be selected from those experience logs, and no trainees during that probationary period.
Event of noncompliance, the license, the credential will be revoked.
Yes.
Okay, so that's the motion. Any further conversation?
I'd like to clarify that, I mean, just to clarify, that should they fail to comply with any part at any stage, that their credential would be revoked.
Well,
Is that the understanding of the motion?
yeah, is it necessary for her to restate the motion in that regard, or?
I mean, it would probably be beneficial. It can't hurt.
Okay,
Just to make sure we're all.
all right. Well, technically, we're supposed to vote on whether she's allowed to amend her motion. All in favor of allowing her to amend her motion, say aye.
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 Any opposed? Okay. Now, Ms. Point.
$5,000 civil penalty to be paid within 30 days, 2 years of probationary period in which they submit a log to be reviewed every 6 months, or reports from that log to be reviewed, no trainees, and at any time if they do not comply, revocation to their license would occur.
Stated. Is there a second before we add conversation?
Second.
Second by Commissioner Walton. Okay. Additional comments? Mr. Stanifer?
Yes, is it correct? Really the recommendation of the reviewer in this case. There are no reports for
The recommendation that I give to you is based on the reviewer reviewing the appraisal that was the subject of the complaint and giving me his opinion. Yeah. No, yeah, you're correct.
We're at this stage, I know you know this from your previous experience. At this stage, this is a sanitized version, and it preserves our ability to act as independent, objective reviewers of the case in the event it goes to an administrative hearing. So we don't know, this is all we know. We don't know who, where, what, other things.
If for some reason the consent order wasn't accepted and it went to a formal, there's probably more information that would come out at that time.
Wouldn't have,
At that time, would we be provided the reports, or I'm just?
whatever
sir.
the state puts
Yes.
on. Yeah, yeah.
No
So-
proof would be put on. This is probable cause. If this is probable cause legal report, and then at a formal hearing, the state would put on proof, including an expert witness.
So your recommendation is based on the recommendation of the reviewer?
Yes.
Thank you, ma'am.
Any other comments before we put this to a vote? Hearing none, all those in favor of the motion, say aye.
Aye.
Any opposed? None opposed, motion passes. Okay, item number 4.
Item number 4, 2013004461. This complaint was filed by a homeowner who was in the process of refinancing a home and alleged that respondent showed up to appraise the home, having forgotten his measuring devices, but proceeded to do the appraisal anyway. Complainant alleged respondent spent approximately 30 minutes evaluating the home, and alleged respondent appraised his home for less than he bought it for in 2007, and the house now has all new renovations. Complainant also alleged that the comparables used by respondent were not appropriate. Respondent sent a response to the complaint stating that he did measure the subject property on the day of the appraisal and that he had not forgotten his tape measure. Respondent indicated that he did include a handwritten sketch illustrating measurements on the back of the order form because he did forget his clipboard and legal pad. Respondent claimed he spent approximately 45 minutes to an hour viewing, measuring, and photographing complainant's home, and stated the comparables used were adequate and appropriate in this case, and that he did not appraise the property in a reckless or inappropriate manner. In regard to the dollar amount stated in the complaint by the owner, respondent indicated he had no predetermined value in mind when appraising any property, and to base his conclusions upon a predetermined expectation of the owner would be unethical. Again, this one was sent to the expert reviewer. His conclusions are listed there. You guys can take a minute to read those if you would like. And there's also, the respondent in this matter did respond to the reviewer's conclusions, and that's listed below. I can read it if you like, or you guys can just review it.
Give us a minute, please.
Okay.
Okay, looks like everyone's done reading. Do I have a motion regarding this? Item number 4.
Make the motion that we accept legal counsel's recommendation of no disciplinary action.
Motion by Commissioner Walton, second by Commissioner Johnson. Any further discussion? Okay, hearing none. All those in favor say aye.
Aye.
Any opposed? Motion passes. Item number 5, please.
Okay, item number 5. There are also 2 matters combined into one here. Complaint was filed by a consumer in alleged unprofessional conduct, bias, and failure to properly analyze highest and best use on the part of respondent. Complainant also alleged that respondent tampered with and changed the appraisal and did not give proper value to the improvements, such as the bridge crossing the river on the property, as well as a historic stone wall and other special features. Complainant alleged that when they purchased the property, it was overgrown and had not been maintained, and that $10,000 was spent hiring a land clearing machine which came through and turned it into a park-like setting along the river. Complainant alleged the property is worth significantly more than the value assigned by respondent. Complainant alleged that respondent appears to be working directly for the city and not as an independent appraiser. In complainant's opinion, by offering a token amount for landowner's property, the city is essentially using eminent domain as their primary means of land acquisition on this project, and respondent is making this possible. Respondent stated in his response that according to the recorded plat in the County Planning Commission zoning ordinance, this property cannot be improved with a residential structure, as periodically it is underwater. The reviewer found no USPAP violations based on the reports, work files, and information provided. After researching the information contained in the appraisal, plat maps, and physical inspection of the property on July 8, 2013, it is the reviewer's opinion that an adequate analysis of highest and best use has been determined for the 1.60 acre tract. The final plat, dated May 20, 2001, clearly indicates and states the County Regional Planning Commission granted a variance on May 13, 2002, to allow a lot to be designated as a non-buildable lot. No buildable permits will be issued until this lot meets all subdivision requirements. Therefore, as of the date of the appraisal, it supports the opinion of highest and best use in that it is not legally permissible to build on this lot. In addition, the reviewer found that the changes made to the appraisal alluded to in the complaint do not affect the value, and no value change was made in the appraisal. No violations of USPAP were observed. As such, council recommends this matter be closed with no further action.
Okay, any questions from commissioners, or would you like to make a motion?
Make a motion that we accept legal counsel's recommendation.
A motion from Commissioner Walton, a second from Commissioner Dr. Barilla. Any further conversation? Hearing none, all those in favor say aye.
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 Any opposed? None opposed, motion passes.
Okay, item number 6, 2013-007511. This complaint was filed by a consumer and alleged that the appraisal report included errors and was not accurate, which caused the complainant to not qualify for a reverse mortgage. Respondent did not send a formal response to the allegations other than the appraisal report and work file, along with an email explaining that he used a wrong term in the opening comment page. This one was sent to the expert reviewer. His conclusions are listed there, as well as the respondent's response to the reviewer's conclusions. So I'll give you guys a minute to look over that.
you're ready, we'll entertain a motion regarding item number 6.
I make a motion that we accept the council's recommendation.
Second the motion.
Motion to accept from Commissioner Point, a second from Commissioner Stanifer. Any comments or questions? Hearing none. All those in favor say aye.
Aye.
Any opposed? Motion passes. Item number 7.
Item number 7 is 2013-01236. This complaint was filed by the administrative staff of the Tennessee Real Estate Appraiser Commission due to a revoked appraisal license in the state of Texas without formal charges, notice of hearing, or a formal hearing. The Texas Appraiser Licensing and Certification Board submitted an order dated May 17, 2013 to this office stating that respondent submitted to the board his affidavit that he no longer desired to be approved as a registered non-resident temporary appraisal. I don't know if I said that right. Non-resident temporary appraiser, and that he voluntarily surrendered his registration. As a result of this affidavit, the board ordered that his registration to practice real property appraisal in the state of Texas be revoked without formal charges, notice of hearing, or a formal hearing. It should be noted that it's Rule 1255-6-.013 states, if a licensee or certificate holder's out-of-state real estate appraiser license or certificate has been revoked, suspended, denied renewal, or restricted, then the Commission may revoke, suspend, refuse to renew, or restrict the licensee's or certificate holder's state of Tennessee real estate appraiser license or a certificate. Respondent filed a response to this complaint stating that the Texas Real Estate Appraiser Board was forwarded a complaint in relation to an appraisal assignment in Texas in 2012. The complaint was made based on the absence of the temporary appraisal permit letter in the initial report. Respondent stated he applied for the permit before the assignment was approved and was to receive the permit via email prior to the effective date of the report. The permit was noted by the Texas Appraiser Board to have been sent prior to the effective date, however, it was not received. Respondent indicated that after being notified by the TALB that a complaint was filed, the initial complaint was cleared up. However, after they reviewed the report, they had several questions as to USPAP compliance. After several conversations with TALB, respondent stated it seemed clear that his best option without further expense for travel and additional counsel was to surrender the temporary license. Respondent stated that at the time, the TALB informed him that vacating the temporary license had no bearing on his professional status anywhere else and no further action would be necessary. It was respondent's opinion that this matter had been resolved and he does not think that this situation should affect his professional certified general status or ability to perform appraisal assignments in the state of Tennessee. Respondent stated that he does not intend to perform such services in other regions anytime in the foreseeable future. And I just made a comment there to make sure that we take note of the rule that I've stated. And this complaint doesn't affect or have any connection to any services that respondents provided in the state of Tennessee. As such, council recommends the commission take into consideration the language of 1255-6-.013 of our rules in determining whether or not disciplinary action is necessary against respondent in this matter.
Right. So I guess the question before the commission is, do we wish to revoke the license based upon the action that occurred in Texas, or do we not, essentially?
There's only one concern that I wanted to raise for the commission, and this is the reason why I filed it administratively, is that temporary practice permits aren't filed on the National Registry. So appraisal credentials, when you get a license in any state, an actual license, you're reported on the registry, and any disciplinary action taken against the licensee is reported on the National Registry. However, if you get a temporary practice in another state, temporary practice permit in another state, but you never hold an actual license in that state. It's the home state's jurisdiction that is covering that authority. So I didn't know what the commission thought about that, but his disciplinary action is not going to be reported on the National Registry through Texas because he doesn't hold a license in Texas.
It does say may, not shall. Just so.
May, yeah, may not shall. It's not to encourage discipline or sway your decision one way or another. It's just merely to give you information on reporting to the National Registry on how that works. It's the home state that reports the National Registry on temporary practice permits. And so I don't think, I don't know, that's the only way it's gonna, that's the only reason that I processed it. I don't know how to.
So this, whatever happened in Texas. We haven't, this is not a complaint that's appeared before the Tennessee Commission.
Just now.
Because, but just because, and he surrendered his license, his temporary license in Texas. So that's basically what triggered this. Were it not for that surrender, we wouldn't have any knowledge of this.
Right, they sent a formal order, formal disciplinary order, but it's not going to be reported to the National Registry because he doesn't hold an actual credential in that state.
I think it's one of those situations where we receive the information as well as let you know there is a rule, but it does say may and not shall.
Well, and we don't have, unless I'm missing it here, we don't know, do we know what the allegations were against this guy or anything? I mean,
My concern is that the respondent indicated that after being notified, then the initial complaint was cleared up, and then after they reviewed the report, they had several questions as to USPAP compliance.
I mean, I suppose if that's something that you would like to get more information on, able to contact them, and if you feel like further information is needed for you to make a decision. Oh, I'm sorry. Do you want me to say that again? If you would like for me to get more information, maybe on what the USPAP issues were, what the allegations were in the Texas issue, I would be happy to try to get that information if it makes you feel more comfortable with your decision.
well,
I don't know. I mean, I feel like reading this, I really don't see any grounds for violations here. There's no details on anything that would lead me to believe there was major issues. None of this would have happened if there weren't some sort of mix-up on the dates of emailing and that kind of thing. It just all sounds very minor, trivial to me.
and he's been a CG, well, he's been a general real estate appraiser since '97, and there's one other disciplinary action, so, you know. Are there any other comments from commissioners, or do I hear a motion?
I make a motion that we dismiss this without prejudice.
Is there a second?
I'll second it.
Discussion? Hearing none. All those in favor say aye.
Aye.
Aye. Any opposed? No opposed. Motion passes.
Okay, item number 8 is 2013014991. This complaint was filed by the administrative staff for the Tennessee Real Estate Appraiser Commission as a result of information received regarding a judgment against respondent in the United States District Court in the Western District of Tennessee. The judgment against respondent consisted of 1 count of conspiracy to defraud the United States and 1 count of wire fraud. Respondent pled guilty to both counts, as well as consented to the criminal forfeiture provision. Respondent was sentenced to 33 months in prison, as well as a significant monetary penalty. It should be noted that respondent's license was indefinitely suspended per final order, and he owes a $20,000 civil penalty, education requirements, plus court and investigation costs. His credential also expired, and he did not complete the required continuing education or pay the renewal fees to maintain the former appraiser credential. The respondent also neglected to send a response that was requested in this matter. Under reasoning and recommendation, I've noted TCA 6239-326, which states the rights of any applicant or holder under a certificate as a state licensed or certified real estate appraiser may be revoked, suspended, or restricted, or the owner of the certificate may be assessed a civil penalty of up to $1,000 per violation or otherwise disciplined in accordance with this chapter upon any of the following grounds: conviction, including conviction based upon a plea of guilty, or I don't know why I put that equal sign in there, nolo contendere, of a crime that is substantially related to the qualifications, functions, and duties of a person developing appraisals and communicating appraisals to others, or conviction of any felony, or any action or omission involving dishonesty, fraud, or misrepresentation. Due to the recent conviction judgment against respondent in the United States District Court, as well as the past history of respondent, counsel recommends revocation of respondent's appraiser credential, effective immediately upon execution of the consent order authorizing revocation, will be settled by consent order or formal hearing.
Okay. Do I hear a motion?
I move that we accept counsel's recommendation.
Second? Okay, second by Dr. Barilla, motion by Commissioner Point. Any conversation? Hearing none, all in favor say aye.
Aye.
Any opposed? No opposition, motion passes.
Okay, item number 9, 2013-01656. This complaint was filed by a homeowner and alleged that respondent did not return complainant's phone calls. Complainant alleged that respondent did an appraisal on a house complainant owned, but when complainant called him with questions about it, respondent refused to answer or return the calls. Respondent sent a response to the complaint stating that the complaint filed was in regards to a property in which complainant was the seller. The appraisal was ordered by respondent's client, a regional bank, for the mortgage lending purchase of the property. Respondent stated that according to the confidentiality section of the ethics rule, an appraiser may not disclose confidential information or assignment results to anyone other than the client unless specifically authorized by the client. Respondent explained that prior to complainant's messages, respondent asked one of the agents involved to inform all parties that any questions regarding the appraisal needed to be directed to the client, as respondent was not allowed to answer questions from agents, buyers, or sellers after the inspection. Respondent reiterates in his response that the complainant was not his client or an intended user of the report, and thus the complaint is not valid. There appear to be no violations on the part of respondent in this matter, thus counsel recommends the matter be closed with no further action.
Right.
Go along with the recommendation.
Motion to accept by Commissioner Johnson. Do I have a second?
Second.
Second by Commissioner Walton. Any comments? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion carries. Item number 10, please. Barrister Baird.
Item number 10. This particular item involves 3 complaints that were previously presented to the commission. They're 2012-025511, 2012-026941, and 2013-001371. Respondent was registered as an AMC in Tennessee in March 2012 and headquartered in Jacksonville, Florida, failed to pay 3 Tennessee certified residential appraisers the amounts of their invoices during the summer and fall of 2012. The amounts owed to each of these 3 appraisers averaged approximately $3,000. Complaints were filed against respondent between October and December of 2012, and on January 25, 2013, respondent filed a voluntary Chapter 7 bankruptcy proceeding and indicated it was closing down its business. This matter was presented to the Commission previously in March 2013, wherein the Commission voted to offer the respondent a consent order of voluntary surrender with conditional authority to file a notice of hearing and charges. Respondent did not sign this proposed consent order this spring, and litigation counsel filed the formal proceeding in July of 2013. In early 2013, 2 of the 3 complainants filed claims with the respondent's surety bond insurer, Lexon Insurance Company, and the invoices of these 2 complainants were paid in full by the insurer by late April or May of this year. The 3rd complainant has indicated he is determining how he wishes to proceed with the insurer. Respondent has no current ability to pay a civil penalty or cost and is still under bankruptcy protection. Further, attempting to collect penalties or hearing costs could implicate possible violation of the bankruptcy automatic stay. However, respondent has recently signed an agreed final order prepared by litigation counsel, which, if approved, would result in the immediate revocation of its Tennessee AMC registration without the assessment of civil penalties or costs. Litigation and commission counsel both recommend that the commission approve the agreed final order signed by respondent, which would revoke respondent's AMC registration. We believe that this sanction is sufficient to protect the public. The respondent has no current ability to pay civil penalties or costs, and any assessment resulting from an order of this commission would likely be uncollectible. Although not completely mitigating, the state would note that 2 out of the 3 Tennessee appraisers who filed complaints have been made whole by the surety bond insurer, which has not occurred to our knowledge in the previous cases we have dealt with involving AMCs that fail to pay invoices.
Okay, is there a motion regarding item number 10?
Recommend that we accept the recommendation of legal counsel.
Second.
By Commissioner Walton, second by Commissioner Stanifer. Any further conversation? No? Hearing none, all those in favor say aye.
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 Any opposed? None opposed, motion passes.
Okay, that concludes the legal report, but I do have one more thing, and I'll try to be really quick about it. I promise. I'm never quick, but I'm gonna be.
Chop, chop.
I just wanted to present this to you guys. It's concerning a matter that was presented to you in the past for a particular respondent whose counsel wrote a letter to the commission that he wanted to be presented to the commission. I'm just going to try to summarize some of it for you. If you have questions, you can stop me. I'm not asking anybody to make any kind of decision on anything. Just wanted to let you know it was there. So basically, the attorney wrote on behalf of the respondent to request the commission reconsider its action and order entered, not because of a violation of law or rule, but as a matter of manifest injustice in the result reached, especially given that what appears to be the primary reason for the staff recommendation to the commission appears to be based on an incorrect characterization of the facts, a mistake, if you will. So basically, what happened in this instance is the commission voted to give this respondent a consent order. He complied with the terms of the consent order. He met all of the requirements of the consent order, the penalties, the education, and whatnot. And then after the fact, I guess he decided that he didn't really want to do that. But he'd already basically settled, signed the order, paid the money, did the education, and then I think he acquired counsel and didn't have counsel before. I think he was feeling like maybe he shouldn't have signed the order. So basically what happened is his attorney has written this letter, I guess, asking you guys to reconsider the action that you took. And I had asked the counsel higher than me what I should do about this. I wasn't even sure if I should present it to you guys at all. And he said that since the counsel asked me to read it to you, that I should just let you guys know that it was out there, just so you know. I know it seems kind of strange because we've never done that before, but I'm just trying to cover all the bases. I can read it in its entirety if you would like, but just so you know it's there.
So, the respondent signed the consent order agreeing to the discipline and the fines that we had imposed. And this was This was after we handled this in a sterilized manner, just as we just did in a legal report.
Correct. And it was presented anonymously, just like they always are. There was nothing different about this.
Is it, so as a matter of due process, can this respondent, even though he signed the consent order and he completed all of those steps, can he still have an administrative hearing, a formal hearing?
We might need to refer to Sam on. I'm under the impression that he signed the order. There's really not anything
done, right?
Yeah, he agreed
Yeah.
to all the requirements, and he completed all the requirements. I think what happened was, after the fact, it says here, he lost 2 substantial sources of recurring appraisal work directly as a result of this turn of events. He's been turned down for renewal by his errors and omissions insurance carrier, with which he's had a 12-year relationship, and the cost for his coverage from another source has doubled. So, I don't know. I mean, I don't really know what to say besides to just kind of report this to you and let you know that it's out there. Because
Thank you. Thank you, Ms. Baird. We appreciate it.
If you have further questions about it, then you can certainly let me know, and I'll answer anything you want me to.
Well, I don't have any other questions. Does anyone else? Okay, hearing none, we thank you. All right, next item on the agenda is the director's report.
I get the luxury of going last and being the most brief. If you turn on your iPads to page 51, the item 1, the Association of Appraiser Regulatory Officials, ARRO, will be meeting October 19th through 22nd. Travel approval has been granted for Mrs. Avers and Mr. Green. Travel approval is still pending on Mr. Baird. But Mr. Johnstone indicated he had a schedule conflict, and so he's not going to be able to attend. There's a notification on the website. It's important that we have an ability for all of our licensees and interested parties to sign up for any potential law or rule changes. So staff has been working to add all of our contacts that ask questions about the 2015 changes, and all of the trainees have been added as we move forward. We're just adding them, but please get the word out that people need to sign up for the notifications on our website. It's in yellow, and all you have to do is click here, give us your name and your email address, and you'll get a notification in your inbox anytime there's a change, law, rule, change, anything. I passed out earlier today the final draft of the newsletter. I'm hoping to post it to the website at the end of this week. So if you have any comments, please give those to me by tomorrow morning. The last thing I wanted to discuss was several applicants in the last couple months have been applying and calling our office, indicating they took education before 2008 that doesn't meet the current requirements. And I'm talking significantly before 2008, like 2004, 2005, or even earlier, some of them. And these aren't courses that are approved under the current matrix. So these are trainees that have been trainees for like 10 years. So they may have taken courses like single family residential or URAR or fundamentals of rural appraisal instead of the course requirements that are currently required, which is basic appraisal principles, basic appraisal procedures. USPAP isn't too much of a problem, but the other courses, you have matrix requirements and you kind of have to fill a slot. So the trainees applying under old education requirements may have to go back. And a lot of them believe that they're grandfathered because they're currently registered trainees. But that is a misconception. And as we move towards 2015, I think we're going to see more applicants applying with very old education. We have trainees that have been trainees for 15 or 20 years, believe it or not, that they just have never tore the Band-Aid off and upgraded. And we probably will as we get closer to 2015. So I think we're going to do some outreach. I'm encouraging you to do this as commission members. Outreach. I don't know what else to do, but I really got to get this message out with regards to if you have any ideas. I realize it's been a problem, but I think it's going to be a bigger problem. It's, also we've been kind of using individual course approval and sort of abusing Dr. Barilla, who has been very, very kind about individual review. It was written into our rules for continuing education. Reviewing continuing education and reviewing qualifying education are two entirely different animals. And generally speaking, the amount of documentation you have to review for qualifying education is inches thicker than continuing education. And he is reviewing both for the application. Well, he's reviewing it for free, but we only charge for trainees or applicants $25 to submit an application. And we're hybriding qualifying education under this continuing education. And they're still angry because we have to make them do what the course providers do, which is submit the matrix requirements. And these trainee applicants filling out a course matrix that the schools like Appraisal Institute or one of the bigger other schools have to fill out a matrix, they're livid when I tell them they have to fill out a matrix. Dennis can back me up on that. When he has to hand talk them through how to fill out a matrix, it is not a friendly conversation. And telling them that, well, it's only $25 is not very soothing to their nerves. It still takes forever. So I don't think this is a Band-Aid that's fixing the problem. And if Dr. Barilla goes away, then we really are going to have a problem for reviewing qualifying education.
So the qualifying ed changed, the rules changed in 2008?
No. Well, it was 2007 the last time the rules changed.
So basically you have trainees that got their QE prior to that, and basically you're saying you're making them prove that it met the criteria, the current criteria post 2007
Well, they're just applying to upgrade now.
to CR or CG.
Right. So they're trainees and their application
They're
requirements.
legitimate trainees.
They're legitimate trainees, but now they're applying to become certified residential, and their criteria to become certified residential are not met.
Their QE for C. Okay.
Yeah, they're
I gotcha.
submitting, instead of the matrix requirements to become certified residential, they're missing two pieces. They're usually missing principles and procedures, and they'll have everything else met, and they're just livid when I tell them, you worked towards this for 7 years, and you got to go back and take 2 more courses.
Well, I could see,
And you're not going to be able to take any courses online, which is another conversation that they get very angry with me about.
is the problem the fact that we're overworking Dr. Barilla, or is the problem that these QE are expiring? What do you want the commission to address? Do you need help, or do we need to visit what we can't fiddle with QE. That's established by the AQB, correct?
Well,
Capiche?
the minimum requirements are established. I think we're going to have to address in the rules how we approve qualifying education for individual basis for qualifying education and continuing education as 2 separate things. Currently, there's nothing in our rules that really addresses how we handle qualifying education on an individual basis. Essentially, it's sort of a vacancy. The rule I cited there, 1255-214, is the only reference to individual review.
I could I could foresee, and I'm going to throw it open to the commission to comment, I could foresee having a contract education reviewer, much like we have a contract appraisal reviewer. And I don't know any qualified educators that would do it, but no, I'm just kidding. But we could.
I would agree with you.
For a fee, he might.
That's why some states only approved AQB approved education, because they just don't have anybody on staff to review education. Like Hawaii, I know just off the top of my head because it's such a small state. The only reason they don't accept education individually, it's not a very good answer, but the reason they don't do it is because they just don't have anybody to review it on one by one basis.
I would ask what people like North Carolina and Kentucky are doing, number one. Number two, I would ask that you bring back what that would cost, get with our esteemed counsel, Dr. Barilla, and see what something like that might cost the commission. And then let's see what the rules, what rule changes we might need.
Right, but I think at this point, we should probably start thinking, and maybe it was something we can address for next commission meeting, policy interpretation for those applicants in the short term, how we're going to address talking to them, because basically I've been telling they just have to go back and do it over again. They're going to come to you. Eventually they're going to get angry and come to you.
You looking
So-
at me? Oh, okay.
That's the you all.
Y'all, okay. Well, other commissioners.
Eventually they're going to come to y'all.
What comments do
They'll
y'all
catch us
have?
at meetings,
Right.
classes. We'll get it.
I know that eventually, right now it's one or two, but eventually it's going to be a bigger problem. And I just want to call it to your attention that eventually we're going to have more of these applicants, and not just trainees, but licensed appraisers wanting to upgrade to certified residential. And if you have really old education and you just have a piece of it, and you think that it will upgrade you to, and it's so confusing because if you didn't have your requirements met before 2008, because the requirements currently allow for education before 2008, and those who didn't complete the requirements before 2008, it's really like, unless you were like me and just around when all the requirements changed,
Well,
how would you know?
let's look at other states, and I don't think I can tell you that the people that I know that are looking to get this approval, you know, if it takes them a couple of grand and weeks to go get this QE, they would probably be willing to pay as much as X, a couple $100 perhaps, to get a QE class reviewed and approved. So if we need to raise fees and hire a outside contract educational consultant, then that would make sense to me.
Many of them don't know how to fill out the application to meet the matrix requirements, though. The matrix requirements for a course provider are hard enough.
Right?
Like, if you're just the education person at Appraisal Institute and you have to fill out the matrix for 50 states, there's like a guy who does that. But if you're just a licensee and I said you have to fill out the matrix to upgrade, and here's the documentation. I know you took this class 6 years ago, but I need the course book and the instructor information and a, timed outline and all this information because you have to meet the same requirements the Appraisal Institute did. I think you're going to be livid.
But can we waive those matrix requirements, or will we be busted by the AQB?
We won't be busted by the AQB. We'll be busted by the appraisal subcommittee.
Okay. But we'll be busted, so we're not
Yes.
going to waive those requirements. So how about if we make the outside educational consultant two-tiered? One tier is review, and a second tier for an additional fee, they help them fill out the matrix.
They'd have to change the rules.
It'd be the matrix revisited, I think.
And the rules,
Let's put it on their agenda for next week.
The rules would have to change. I don't know if you could change the rules before 2015 to address it in time to help the first wave. I think really the first answer is just let the licensees know, because we're going to do a major rulemaking to just get the rules before 2015.
I tell you what, I would entertain a motion to defer this until the November meeting so that as we go to Aero and we talk to other states, we can get some input and get some feedback, and also we can consult with educators and maybe get a proposal together for the commission to consider. So I
Okay.
would entertain a motion to that effect.
So moved.
Thank you. So a motion and a second. Any more conversation? Since I've been doing it all, sorry. None? Okay, all those in favor?
Aye.
Any opposed? Okay. Ms. Avers?
Oh,
All right, talk to us about the October meeting.
October.
Are we having, are we having an October meeting?
Yes.
Okay.
Yes.
Okay, and it's just whatever we have scheduled?
It's the
There's no
second
change?
Monday. Yes, I will get that information out to you very shortly. I just don't recall, I can't recall the date exactly off the top of my head right now. Oh, the governor always calls that one though. Columbus Day?
Yeah.
The governor always acknowledges it as the day after Thanksgiving.
Yeah.
So he always moves Columbus Day to the day after Thanksgiving.
So we will be meeting, will there be a formal hearing at this point that you know of?
It is my belief that there will not be.
Yeah, I don't really know.
Okay, so we don't know yet. So,
I don't recall anything.
all right.
Based on my last conversation with litigation counsel, there's been a request to defer or to
I think the one that was set for October might be getting pushed back.
Well, if there's no hearing and we have a light agenda, we might consider, we'll see, we might consider. Yeah,
November?
yeah.
But then you'll miss my legal report and you'll be sad.
This was going to be the short one.
Boo-hoo Baird.
We're
Okay.
done.
All right, very good. Well, with no further agenda items, we stand adjourned. Yippee. Very nice. Thank you for all your motions. We missed you this morning. We were motionless without you.